hearing dates which are subject to the approval by the JP. But from past experience, when we have requested specific dates, we have been accommodated.
Very well, thank you. Is there a draft of that proposal that you want to send through to the court so that we see what the timelines are?
Yes, Mr. Badlander has got the original draft, so we will, between me and him, will ensure that it's sent through the next few minutes. Mr. Badlander?
Yes, thank you, Mr. Mpofu. I have it ready. I'm just going to send through the agreed version as distributed on the WhatsApp group this morning, and I'll send it to Ms. Bawudeen, if that's in order, Judge.
That's right, thank you.
I've just hit send on it, and you'll see that it's got a timetable for the filing of affidavits and heads, and with the hearing date envisaged to be the 24th to the 26th of November of this year.
Good, well, thank you for that. It's some progress in that. Is there any other housekeeping? Yesterday, we didn't divvy up any time, and so we were left with literally no more than 10 minutes for Mr. Sikakane to make his presentation. So we did like to avoid that today. Mr. Breitenbach, how long do you anticipate you will be on your feet?
I have agreed with my learned friends, Mr. Badlander and Ms. Bauer, that I will finish at 2:45 at the latest.
2:45, Mr. Badlander?
Yes, I will need 45 minutes, Judge.
Okay, that takes us to 3:30. Ms. Bauer, how long do you need?
I probably need about between 15 to 20 minutes.
Okay. And then we have Mr. Mpofu and Mr. Sikakane in reply. Is there anything from your side, Mr. Weston, that you're going to be saying?
No, I won't be saying anything, Judge.
Good. Thank you.
Okay. One other housekeeping matter. I realized that we would be pressed for time. And so overnight, I've converted the notes that I intend working from into a document which can be used by my opponents and by the court to alleviate the burden of note-taking. I've sent it to my colleagues. I did so at 9:30 this morning as soon as it was finished. And it is ready to be sent to the court, and a junior is waiting in the court building to hand it over to you should my colleagues not object to it being so handed over and used by you, and obviously the court agreeing to accept it.
Thank you, Mr. Breitenbach. Your voice seems to be breaking slightly. Is that an experience of others, or is it just us?
Hello.
Can everybody hear Mr. Breitenbach?
Yes, I could.
It was breaking up slightly, Judge, but perhaps if we all turn off our cameras apart from Mr. Breitenbach and yourself, that will improve the bandwidth and that may solve the problem. So perhaps we should do so now.
Lord, may I address the court for a minute?
Certainly.
Lord, my understanding yesterday, unless I got it wrong when you implored us to deal with the timetable, my understanding was that the court and I at least were trying to curtail the proceedings today. Unless my understanding was mistaken, I thought once the timetable is agreed upon, it would render unnecessary the hearing today. I may have misunderstood completely what the attempts were about.
Mr. Sikakane, as I indicated at the beginning of the proceedings yesterday and at the end, that a timetable would be helpful for the parties to agree upon. It would also assist the court in terms to see what the timelines are. And I did say very specifically yesterday that notwithstanding the timetable, the matter proceeds, and this court has heard the argument from the applicants. The respondents will address the matters, and then the court will proceed to a determination. So The timetable doesn't obviate the need for these proceedings, in as much as the parties have not come to any agreement with regard to Part A. And so the matter is still alive before the court.
Thank you, my lord.
Good, thank you.
Yes, my lord. From my side, may I confirm that when I confirmed our agreement to the details of the timetable, I informed all of my colleagues via the group that we use that the agreement to this Part B timetable does not mean any agreement to hold off the Section 194 process until then.
Thank you. Mr. Qibani, does that address your concern?
No, it doesn't, my lord, but I will let it pass because I think the parties, where there was a misunderstanding. We engaged in this process. My understanding, as the court has corrected me, was a different one. And even what Mr. Breitenbach is saying, that he alerted us of this thing, he actually alerted us right at the end of the agreements when we had secured the dates. And Mr. Mpofu, on the other hand, made that his point known right at the beginning about this. So I think there was an attack of, there was a lack of transparency in how, or there was a misunderstanding in how we were dealing with this. Thank you, ma'am.
Thank you, Mr. Qibani.
My lord.
Yes, Mr. Mpofu?
Yes, thank you. Yeah, maybe I may assist. What happened is actually what has been happening over the few months. Well, I think the first thing that happened after when we had our first attempt at talking was that we just repeated our offer that if the matter is, or rather if the process is suspended, then obviously there would be no need, particularly now that we have agreed on an expedited program for Part B. But my understanding was that offer, if you like, from us was rejected by the speaker once again. So if it has been rejected, then your lordship is correct that then the court still has to determine what happens between now and the 24th of November.
Yes. Thank you. Mr. Breitenbach, we can proceed.
Lord, I just wish to ask for your ruling on whether I can make the note available to you. It will greatly speed things up.
Oh.
Mr. Mpofu, yes.
I'm sorry, my lord. Mr. Breitenbach, we certainly don't have the note. Maybe your attorney can send it to my attorney.
I sent it to you on the WhatsApp group at 9:30 this morning, Mr. Mpofu.
Okay, okay, then I can check that. Yeah, okay, I got it. Thanks.
Good, and there's no objection from any of the parties to the note which will facilitate the argument by the first respondent. Thank you.
No,
Mr. Breitenbach, you may proceed. The note has been received by the court. Thank you.
Thank you very much, my lord. In paragraph 2 of Part A of her notice of motion, Advocate Qibani seeks an interim interdict pendente lite. She asks this court to prohibit the speaker from taking any further steps in the implementation of the processes envisaged by Section 194 of the Constitution in relation to a motion for her removal from the Office of the Public Protector, the currently operative motion being the one submitted by the current Chief Whip of the Democratic Alliance, Ms. Mazzoni, on the 21st of February 2020. If granted in the terms in which it is sought, the interim interdict will operate pending the final outcome, and I stress that, the final outcome of proceedings for the relief Advocate Qibani seeks in Part B of her notice of motion, most notably an order declaring to be unlawful, unconstitutional and invalid, null and void, new rules in relation to Section 194 of the Constitution adopted by the National Assembly on the 3rd of December 2019. In the alternative to the interim interdict in paragraph 3 of Part A of her notice of motion, Advocate Qibani seeks a final order prohibiting, and I quote, those respondents and or their members who have a conflict of interest from voting and or participating in any way in the processes carried out in terms of Section 194 of the Constitution and the rules. And in paragraph 4 of Part A, she also seeks an order directing and I quote, the conflicted persons, unquote, to declare their interests to the Speaker. Advocate Qibani has not cited as respondents in this matter any of the individuals named and unnamed in her affidavit against whom she seeks this interdict, as was pointed out yesterday by His Lordship presiding. We shall deal with 9 topics. First, to frame the rest of our submissions, we outline the key events giving rise to and following the institution of the present proceedings on the 4th of February 2020. Secondly, we deal briefly with Advocate Qibani's application to strike out parts of the Speaker's answering papers. Third, we deal with Section 194 of the Constitution, focusing on first, the constitutional function it serves, that is, as the ultimate mechanism for holding accountable incumbent Chapter 9 office bearers, and second, the respective roles and responsibilities of the National Assembly and the President in impeachment proceedings under Section 194 of the Constitution. Fourth, we outline the new NA rules, which define the grounds of removal and regulate the process in the NA. Fifth, we give an overview of the legal principles governing applications like the present, where the main relief sought is an interim interdict restraining the exercise of a public power. Sixth, to save time, we outline together our main points based on the facts and circumstances of the present case regarding the requirement of a reasonable apprehension of irreparable harm, the balance of convenience, and the absence of a suitable alternative remedy. We shall submit that none of the limited harm from the continuation of the NA process which Advocate Qibani claims in her papers is irreparable, whereas the granting of the interim interdict will preclude the NA from carrying out a constitutionally mandated accountability function for what could turn out to be a lengthy period of time. We shall also submit that the main proceedings, Part B, provide Advocate Qibani with a suitable alternative remedy. In the more than 6 months since Advocate Qibani instituted the present proceedings on the 4th of February, she has taken no steps to advance her main application for the relief sought in Part B of her notice of motion. Both in her founding affidavit and in her counsel's heads of argument, she has said she intends supplementing her papers before the set down and hearing of Part B. Seventh, we deal with the question whether, as implied by the reliance on procedural fairness by Advocate Qibani and the ATM, the 16th respondent, the making of the new rules and their implementation is in an impeachment process is administrative action under the Promotion of Administrative Justice Act 3 of 2000, PAJA. Eighth, we will deal as briefly as possible with those of the 10 grounds on which Advocate Qibani intends challenging the new rules in the main proceedings, which her counsel and the ATM's counsel have addressed in oral argument. We shall submit that none of the intended challenges comes close to meeting the high prima facie right requirement in a case like the present. Ninth, and finally, we shall deal briefly with Advocate Qibani's alternative prayer for a final interdict prohibiting the Speaker and other unnamed members of the NA from participating in the Section 194 process because of alleged conflicts of interest. That brings me then to the key factual events. Now, as the court knows, the background facts are set out in the Speaker's answering affidavit and are summarized with reference to the record in 2 sections of our heads, namely paragraphs 23 to 17, which concerns the events leading up to the adoption of the new rules on the 3rd of December 2019, and paragraphs 97 to 130, the relevant events thereafter. They are largely common cause. We submit that 20 key events have given rise to and followed the launching of this litigation on the 4th of February 2020. First, on the 19th of October 2016, which was during the 5th Parliament constituted after our 5th Democratic General Election in April 2014, Advocate Qibani became the Public Protector. Second, on the 17th of August 2017, in an application brought by the South African Reserve Bank, the SARB, and in which the then Speaker, Ms. Mbete, and the then Chairperson of the Portfolio Committee on Justice, Dr. Motshekga, joined as co-applicants, Murphy J., sitting in the Gauteng Division of the High Court, upheld a review challenge to the remedial action in paragraph 7.2 and 8.1 of Advocate Qibani's 17 June 2017 report on an investigation into allegations of public funds and failure by the South African government to implement the CIEX report. We shall refer to this as the CIEX report. Paragraph 7.2 of the CIX report obliged the chairperson of the Portfolio Committee to initiate a process to amend Section 224 of the Constitution to alter the mandate of the Reserve Bank. Paragraph 8.1 obliged the chairperson of the Portfolio Committee to report back to Advocate Qibani within 60 days on the steps taken to implement paragraph 7.2. There was no appeal against Murphy J's judgment or any of his orders. Some of the findings adverse to Advocate Qibani and Murphy J's judgment, which is reported as South African Reserve Bank v. Public Protector and others, 2017 6 SA 198GP, we shall call it SARB v. PP1, underlie two of the charges in the DA's current notice of motion for Advocate Qibani's removal from the Office of the Public Protector. We refer to in this regard to our heads at paragraphs 30 to 32, which correlate to the Speaker's answering affidavit, paragraphs 16 to 23, and also to our heads, paragraphs 116.2.1 and 116.2.3a. Those summarize the relevant charges, read with the charge sheet itself, which is Annexure TRM 60, paragraphs 1 to 3, and paragraph 7.1. I mention this because in her notice of application to strike out paragraph 1, which is in the notices bundle at page 91, Advocate Qibani seeks to have struck out the Speaker's answering affidavit, paragraphs 16 to 23. In other words, the parts which describe the CIEX report and the SARB v. PP1 litigation before Murphy J. The striking out is sought on the basis that those paragraphs are irrelevant and vexatious. Third, the third significant event is on the 16th of February 2018, a full bench of the Gauteng Division of the High Court upheld further proceedings for judicial review of the CIEX report, brought by Absa Bank, the SARB, the Minister of Finance, and the Treasury. These proceedings were directed at paragraph 7.1 and 8.1 of the remedial action, which required the President to reopen inquiries by the Special Investigating Unit, the SIU, for the recovery of 1.125 billion rand of public funds which Advocate Qibani found had been misappropriated and unlawfully given to Absa. Some of the findings adverse to Advocate Qibani in the full court's judgment, which is reported as Absa Bank Limited and others v. Public Protector and others, 2018 Volume 2, All South Africa 1, Gauteng Province, and we shall call it Absa v. PP, moved the court to order that she personally pay 15% of the SARB's costs on an attorney and client scale, including the costs of 3 counsel. Those findings too underlie the charges relating to the CIEX report in the DA's current notice of motion. See our heads, paragraph 33, paragraphs 38 to 39, and paragraphs 116.2.1, 116.2.3a, which must be read with Annexure TRM 60, paragraphs 1 to 3, and paragraph 7.1. Advocate Qibani has not applied to strike out any parts of the Speaker's answering papers relating to Absa v. PP litigation before the full court. The fourth significant event was the appearance of Advocate Qibani on the 6th of March 2018 before the Portfolio Committee to brief it on 3 things: her report on allegations against maladministration against the Free State Department of Agriculture, the Vrede Integrated Dairy Farm report, which also concerned an organization called Estina. We shall call that the Vrede Dairy report. Also on the CIEX report, and thirdly on the litigation in the High Court concerning the Vrede Dairy report and the CIEX report. By that date, 6 March 2018, the DA and the Council for the Advancement of the South African Constitution, KZAC, had launched proceedings in the Gauteng Division of the High Court for judicial review of the Vrede Dairy report, and those proceedings were pending. We refer in this regard to our heads, paragraphs 41 to 43, which correlate to the Speaker's answering affidavit, paragraphs 37 to 40. In her notice of application to strike out paragraph 2, Advocate Qibani seeks to have struck out the Speaker's answering affidavit, paragraphs 16 to 23, which describe the Vrede Dairy report, referred to Advocate Qibani's appearance before the Portfolio Committee on the 6th of March 2018, and referred to the then pending proceedings for judicial review of the Vrede Dairy report brought by the DA and KZAC. The striking out is sought on the basis that those paragraphs are irrelevant and vexatious. In her founding affidavit, however, Advocate Qibani makes extensive allegations regarding the events at the Portfolio Committee meeting on 6 March 2018. In her answering affidavit, it's the Speaker's answering affidavit, in addition to giving the information which Advocate Qibani seeks to have struck out, the Speaker responded to those allegations. The relevant passages are summarized in our heads. Paragraph 204, pages 99 to 100. The fifth significant event occurred on the 27th of November 2018, when the Constitutional Court heard and reserved judgment in an application by Advocate Qibani for leave to appeal against the personal costs order made against her by the full bench in Absa v. PP on the 16th of February 2018. The sixth event occurred on 20 May 2019. Tolmay J, sitting in the Gauteng Division of the High Court, upheld the DA's and KSAC's judicial review challenge to the Vrede Dairy report. Tolmay J postponed a decision on the appropriate costs order in the light of the facts that the DA and KSAC had asked that Advocate Qibani be ordered to pay the costs of the proceedings in her personal capacity. And at that juncture, the CC had not yet delivered its judgment in Advocate Qibani's application for leave to appeal against the personal costs order made against her by the full bench in Absa v. PP. Some of the findings adverse to Advocate Qibani in Tolmay J's judgment on the merits, which is reported as Democratic Alliance v. Public Protector in a related matter, 2019, Volume 3, SA 127 GP, we shall call it DA v. PP 1, underlie a further two of the charges in the DA's current notice of motion for Advocate Qibani's removal from the office of PP. We refer in this regard to our heads paragraphs 116.2.2, 116.2.3b, read with Annexure TRM 60, this time paragraphs 4 to 6 and 7.2. Advocate Qibani has not applied to strike out any parts of the Speaker's answering papers relating to DA v. PP1. The seventh event occurred on 22 May 2019. Following our sixth Democratic general election on the 8th of May, the sixth Parliament was constituted and the current Speaker, Ms. Medise MP, was elected. In addition, the Portfolio Committee was reconstituted and Mr. Magwanisha replaced Dr. Motshekga as its chairperson. The following day, this is the 8th event, on the 23rd of May 2019, Mr. Steenhuisen MP, the then Chief Whip of the DA in the National Assembly, which is the official opposition, submitted a request for the removal of Advocate Qibani from the Office of Public Protector in terms of Rule 337B, that's National Assembly Rule, and Section 194 of the Constitution. Ninth, on the 10th of July 2019, the Speaker wrote to the Chairperson of the Portfolio Committee, instructing the committee to consider and report to the NA on the request and to conduct an inquiry in terms of Section 194 of the Constitution. 10th, on the 22nd of July 2019, the Constitutional Court handed down judgment in Advocate Qibani's application for leave to appeal against the personal costs order made against her by the full bench in Absa v. PP. By a majority, the CC dismissed that application. The case is reported as Public Protector versus the Reserve Bank, 2019, Volume 6, SA 253 Constitutional Court, and is referred to in our heads at paragraph 57. We shall call it PP versus SARB CC. In its judgment, in that case, the majority of the Constitutional Court severely criticized the CIEX report and Advocate Qibani's conduct. And in this regard, we refer you to pages 28 and 29 of our heads of argument. And I intend to read to the court the criticism summarized there, because I know that there is a wider audience. It's not because I know obviously the court has read these passages. With your permission, they are relevant to submissions that I'm going to make later in connection with the public interest in this process being allowed to continue. What the Constitutional Court said, the majority said firstly in paragraph 205 of its judgment, was the following. In this court, the public protector has contended that the adverse findings made against her by the High Court were based on innocent errors on her part. The public protector's persistent contradictions, however, cannot simply be explained away on the basis of innocent mistakes. This is not a credible explanation. The public protector has not been candid about the meetings she had with the presidency and the state security agency before she finalized the report. The public protector's conduct in the High Court warranted a de bonis proprius personal costs order against her because she acted in bad faith and in a grossly unreasonable manner. In paragraph 207, the majority said the public protector's entire model of investigation was flawed. She was not honest about her engagement during the investigation. In addition, she failed to engage with the parties directly affected by her new remedial action before she published her final report. This type of conduct falls far short of the high standards required of her office. In paragraph 218, the majority added, there is no merit in any of the grounds of appeal advanced by the public protector to justify this court's interference in the High Court's exercise of its true discretion to order that the public protector pay 15% of the Reserve Bank's costs in her personal capacity. And lastly, in paragraph 237, the majority said, regard must be had to the higher standard of conduct expected from public officials and the number of falsehoods that have been put forward by the public protector in the course of this litigation. This conduct included numerous, quote, misstatements, unquote, like misrepresenting under oath her reliance on evidence of economic experts in drawing up the report, failing to provide a complete record, ordered and indexed, so that the contents thereof could be determined, failing to disclose material meetings, and then obfuscating the reasons for them and the reasons why they had not previously been disclosed, and generally failing to provide the court with a frank and candid account of her conduct in preparing the report. The punitive aspect of the costs order therefore stands. Now these findings, I'm back at my note in paragraph 5.10 on page 8. These findings, Advocate M. Qibani and the judgment of the majority, also underlie the charges relating to the CIEX report in the DA's current notice of motion. We refer to our heads paragraph 58 and paragraphs 116.2.1, 116.2.3a, which must be read with Annexure TRM 60, paragraphs 1 to 3 and 7.1. Advocate Qibani has not applied to strike out any of the parts of the Speaker's answering papers relating to PP SARB CC. The 11th event occurred on the 15th of August 2019. Tolmay J. handed down her judgment on the reserved issue of costs in the judicial review proceedings by the DA and KZAC for judicial review of the Freda Dairy report. Tolmay J. ordered that the PP in her personal capacity pay 7.5% of the attorney and client costs of each of the DA and KZAC, including the costs of two counsel. In her judgment, which is reported as Democratic Alliance v. Public Protector, Council for the Advancement of the South African Constitution versus Public Protector, 2019 for All South Africa 79 GP, and we shall call it DAV PP2, Tolmay severely criticized the Freda Dairy report, as well as Advocate Qibani's investigation of the matter and her conduct in the ensuing judicial review proceedings by the DA and KZAC. Like Tolmay J's findings adverse to Advocate Qibani in DAPP1, which is the judgment on the merits, you'll recall, her findings in DA versus PP2, the judgment in costs, underlie the charges relating to the Freda Dairy report in the DA's current notice of motion. See our heads paragraphs 116.2.2, 116.2.3b, which must be read with Annexure TRM 60, paras 4 to 6 and 7.2. Advocate Qibani has not applied to strike out any of the parts of the Speaker's answering papers relating to DAVPP2. The 12th significant event occurred on 27 August 2019, when the Portfolio Committee reported to the Speaker on Mr. Steenhuisen's 23 May 2019 request that the National Assembly remove Advocate in Qibani from the Office of Public Protector. The Portfolio Committee noted that no rules were in place to regulate the removal of office bearers of Chapter 9 institutions. It was of the view that rules were necessary to ensure the fairness of the process. It requested that the Speaker urgently refer to the matter to the National Assembly's Rules Committee, which she duly did. 13th, between 10 September and 26 November 2019, the Rules Committee and the Subcommittee on the Review of the NA Rules met 4 times about new rules to regulate the removal of office bearers of Chapter 9 institutions, and the members of those committees eventually, and particularly the Rules Committee, eventually agreed on a set of proposed rules. The 14th event occurred on the 3rd of December 2019 when the National Assembly unanimously adopted the Rules Committee's report, thereby also adopting the new rules, and we emphasize that that was a unanimous decision. The new rules are part of Chapter 4 of Chapter 7 of the National Assembly Rules. They comprise 6 definitions and new rules 129R to 129AF, and they were accompanied by a consequential amendment to National Assembly Rule 88. There are 2 copies of those rules in the papers, Annexure 7 to the founding papers, pages 142 to 147, that is sections D to E of the report, and then a clearer copy, which is TRM 37, 475 to 480 at D to E. May I ask the court, the members of the court, just to take out one of those annexures, perhaps the second one, TRM 37, because I shall be referring to it from time to time. In fact, I shall start by referring to an often, it seems, overlooked aspect of the report which was adopted, in other words, of the new rules. It's right at the end of the relevant section. This is section E. It's on page 480 of the record, depending on whether you're looking at TRM 37 or at 147 if you're looking at Annexure 7. And it's the amendment to Rule 88.
Breitenbach, I think the court's using the copy of the rules provided to us in PPF A7. That's the first one. We've on volume 2.
That's fine, my lord. So that's at page. That's it. I have it here. It's at pages 337 and following. But I may have. Sorry, I've got the. I apologize. I've got the wrong annexure. Annexure 7 to the founding affidavit.
Yes. 142.
Let me just take it out so that I'm on the same page as you are, my lord. May I ask you to turn to the last page, page 147 of that annexure?
Yes.
I'm referring to section E, which is an amendment to another rule, Rule 88, reflections upon judges and certain other holders of public office. And as the court will see, that the rule has been amended by removing the words at the end, which, if true, would, in the opinion of the Speaker, prima facie warrant such a decision. It now reads, no member may reflect on the competence or integrity of a judge of a superior court, the holder of a public office in a state institution supporting constitutional democracy, referred to in section 194 of the Constitution, or any other holder of an office other than a member of the government, whose removal from office is dependent upon a decision of the House, except upon a separate substantive motion in the House presenting clearly formulated and properly substantiated charges. Now, new rule 129R, which is on page 144, makes provision for such a motion in the case of a member wishing to ask the House to sanction the removal of a Chapter 9 office bearer. So I emphasize that simply because quite a lot has been said in this case about people expressing views adverse to the public protector, including people who have tabled motions of this kind. It is clear, as we shall see in a moment, that one of the functions of the National Assembly is to hold office bearers, Chapter 9 office bearers, to account. And if they believe that their conduct warrants the ultimate sanction of removal. They will obviously have to, in motivating that, reflect on the competence or integrity of such a person, depending on the facts. That is something which the rules sanction and have to sanction, otherwise Parliament couldn't perform its function to hold, amongst others, Chapter 9 office bearers to account. Returning to the chronology, the 15th significant event occurred on the 6th of December 2019, and it was when Ms. Mazzoni, who was the new chief whip of the DA, withdrew Mr. Steenhuisen's 23 May 2019 request for the removal of Advocate Qibani from the Office of Public Protector and submitted a new request in terms of the new rules, alleging, based on the same grounds as Mr. Steenhuisen has, and on an additional ground deriving from the judgment of the majority of the CC in PP versus Saab CC, that Advocate Qibani is incompetent. I emphasize that was the basis of that particular motion. The relevant part is of our heads is paragraph 97, and Ms. Mazzoni's covering letter is TRM 39, and the motion itself is TRM 40, pages 485 to 488. The 16th event occurred on the 24th of January 2020, when, after considering Ms. Mazzoni's request and notice of motion, the Speaker was satisfied that the notice of motion complied with the form requirements of the new Rule 129R, to which I shall turn in a little detail later. The Speaker consequently announced to the NA her receipt of Ms. Mazzoni's notice of motion and invited the political parties to nominate by 7 February 2020 candidates for the appointment to the independent panel in terms of Rule 129V. 17th event was on the 4th of February when Advocate Qibani launched the present application. The 18th event occurred on the 21st of February 2020 when Ms. Mazzoni withdrew her notice of motion of 6 December 2019 and submitted a new one for the removal of Advocate Qibani. It's far more detailed than her earlier motion. It includes additional charges, including charges of misconduct and additional charges of incompetence. It's described in our heads at page para 112, and it must be read with the following annexes: TRM 59 at page 539, which is Ms. Mazzoni's letter, and TRM 60, pages 540 to 550, which is the new notice of motion and the charges against Ms. Advocate Qibani. Not attached to the papers, but submitted with it, was the evidence referred to in the charge sheet on which it was based. 19th, on the 26th of February 2020, the Speaker considered Ms. Mazzoni's second notice of motion and was satisfied that it conformed with Rule 129R. And the reasons for that, which derive from the answering affidavit, are set out in our heads, paragraph 116 at pages 52 to 55, which we commend to the court because they give an overview of what the charges are, and, as we shall see later on, why the Speaker considered that the motion complied with the new Rule 129R. The Speaker then, and that was on the same day, informed Advocate Qibani and the party whips accordingly and requested that the party whips submit new written representations by 6 March 2020 for the appointment to the independent panel. We referred to that in paragraphs 118 to 119. For present purposes, however, it's important to note that the Speaker considered, with respect correctly, that the withdrawal of the first motion brought the earlier process to an end, and her approval of the new motion meant that the process had to start afresh. The 20th and last event to which we wish to refer, and this is in the papers, there's one event which is not in the papers but is common cause of which the court has been informed, is that on the 20th of March, after all the parties had delivered their papers, the last of the replying papers having come in 3 days earlier, the parties informed the Judge President that due to the COVID-19 pandemic and the consequent suspension until further notice of the business of the National Assembly, including the processing of the motion for the impeachment of Advocate Qibani, the hearing of Part A, which had then been set down for 26 and 27 March 2020, would be postponed sine die. The court will know that the hard lockdown started at midnight on the 26th of March 2020. On the 8th of June 2020, the Speaker decided to resume the processing of the motion for the impeachment of Advocate Qibani and informed her, Ms. Mazzoni, and the other parties in the present matter accordingly. And thereafter, by agreement, the Judge President was requested to enrol Part A for hearing yesterday and today by this court, which he duly did. As yet, however, the Speaker has not appointed anyone to the independent panel, which is the next step in the process required by the rules, but she is busy with that process and will continue with it unless interdicted by this Honourable Court. That then brings me to the second topic, which is Advocate Qibani's application to strike out. I've identified the four passages, or three of the four passages. There's an annexure, which is a minute of a meeting. It seemed to us to be a rather inconsequential meeting, included in the Speaker's very full account of the chronology. You know that Advocate Qibani is persisting with the application to strike. It's in their notices at pages 90 to 103. It's addressed in her counsel's heads of argument at paragraph 67 to 71, admittedly without any specifics. Paragraphs 1.1 to 4 of that relate to the Speaker's answering papers. That's in notices on page 91. In our heads at pages 126 to 131, paras 254 to 258, we outline the applicable legal principles, and we deal fully with the reasons why in our submission the application to strike out should be refused with costs. The only thing that we wish to add to what we've stated there is that there is a mistake, for which we apologize. The date of the Constitutional Court hearing in the Bosasa case given in our heads at paragraph 257.10 on page 130. That is the date given there is 20 September. That's a typo. It should be 29 September 2020. Otherwise, we have nothing to add to what we've stated in our heads of argument. That brings me to the first substantive topic, which is section 194 of the Constitution. And in our heads at paragraphs 10 to 22, we discuss section 194 of the Constitution, including the constitutional function of impeachment proceedings, in other words, as the ultimate mechanism for holding incumbent Chapter 9 office bearers accountable, and the respective roles and responsibilities of the National Assembly and the President in section 194 impeachment proceedings. Again, because this address is being broadcast to a wider audience, I request leave to be able to read section 194 to frame what I'm going to say. It provides for the removal from office of the Public Protector, the Auditor General, or a member of a commission established by Chapter 9 of the Constitution. Subsection 1 provides that they may be removed from office only on A, the ground of misconduct, incapacity, incompetence. And if the court is so minded, it could compare those grounds with the grounds in section 89 for the removal from office of the President, which are a serious violation of the Constitution or the law, serious misconduct, or inability to perform the functions of office, and also with the grounds for the removal of judges, which are in section 177A, namely incapacity, gross incompetence, or gross misconduct. So here one has something which on the face of things is a lesser standard. Words, adjectives like serious, gross are missing here. The significance of that will become apparent later when we look at the definitions in the rules. The second requirement is that there must be a finding to that effect. In other words, that there was misconduct in capacity. Yes, Ms. Madu.
Yes, we don't have a copy of the of the rules adopted by Parliament relating to the impeachment of the President. Is that available?
Yes, I will certainly make that available to you. I will, if you just bear with me 1 second. My Lord, I'm sending a copy to one of my juniors now, and I will ask that he emails, just checks that it's correct. It's an MS Word copy of NA Rules 129A to 129Q. And
sorry, Mr. Breitenbach. My Lord, I just wanted to point out, maybe to assist, that those rules are already in the papers.
Yes.
165. PPF
165.
165, my Lord, yes. Attached to the applicant's founding affidavit.
Thank you, Mr.
Thank you, my Lord. May I continue?
Yes, certainly.
I'm returning to 1941. The Public Protector, Auditor General, or a member of a commission established by Chapter 9 may be removed from office only on, firstly, the ground of misconduct, incapacity, or incompetence. Secondly, a finding to that effect by a committee of the National Assembly. And thirdly, the adoption by the Assembly of a resolution calling for that person's removal from office. So 3 requirements: the objective requirements of misconduct, incapacity, incompetence. Secondly, a finding to that effect by a committee of the NA. And lastly, the adoption by the Assembly of a resolution calling for that person's removal from office. Now, subsection 2 establishes different voting thresholds depending on whose removal is sought. 2A says such a resolution, if it concerns the Public Protector or the Auditor General, must be adopted with a supporting vote of at least 2/3 of the members of the Assembly. In other words, 2/3 of the 400 members. And if it concerns a member of a commission established by Chapter 9, must be adopted with a supporting vote of a majority of the members, in other words, 201 or more. And then sub 3 deals with the President's powers in this process. Firstly, the President may suspend a person from office at any time after the start of the proceedings of Committee of the National Assembly for the removal of that person, and must remove a person from office upon the adoption of the Assembly of the resolution calling for that person's removal.
Mr. Breitenbach, might I ask at this stage, the rules doesn't deal with the suspension, the process of suspension by the President, does it?
Not at all.
Now, when the President seeks to suspend, is there any obligation on the President to give the person concerned notice of an intention to suspend for representations to be made or not?
I do not wish to make a firm submission on that.
Yes.
It is a constitutional function which is being performed,
Yes.
and it is obviously arguable that it is covered by the definition of administrative action, which, as the court knows, includes, in relation to organs of state, decisions by an organ of state when exercising a power in terms of the Constitution which adversely affects the rights of any person and has a direct external legal effect.
Yes.
The President is represented in these proceedings and may wish to make submissions, but I can see the argument for the applicability of PADGA, and which, if it applies, will then bring with it Section 3, which will be a right to be heard.
Yes.
As far as the dealing of the rules with this aspect is concerned, the only relevant provision is that if the National Assembly decides to constitute a Section 194 committee, then Rule 129Z sub 3 requires that the President be informed of that. And the reason for that is, amongst others, I would imagine, because that is the condition precedent, or the start of the proceedings of such a committee is the condition precedent for the president's power to suspend. So the Speaker must inform the President of any action or decision emanating from the recommendations, one of which in sub 2 129Z is a resolution that of section 194 inquiry be proceeded with, and that then requires that the matter be referred to the committee, the composition and functioning, etc., of which is then dealt with in the further rules AA, AB, AC, AD, and AE.
So notionally, once the National Assembly has taken a resolution, at that point in time, the person concerned is vulnerable to suspension once the President has been informed.
Yes.
And that would entail that that person ought to receive notice even if a suspension is intended to be made by the President. It's an obvious lacuna in these rules, and whether it should have been addressed in these rules or not, it's a matter that might be dealt with later.
With respect, I'm not going to concede that it was a lacuna for one reason only. The National Assembly has the power to regulate its own processes under section 57 by means of these rules.
Yes.
The matter which your Lordship is touching on is a process inside the executive, inside the presidency.
Yes.
So these are internal process rules, and there is this interface with the executive, in fact with the President probably acting in his capacity as head of state. Yes. in this particular respect. So that's the first submission I would make. Secondly, if PAJA is indeed applicable, then section 2, obviously, of PAJA means that it does apply unless an exemption is granted by the Minister of Justice. So if it's administrative action, that decision, not executive action,
yes.
Then PAJA would apply. But I will leave it to Ms. Bauer to deal with that aspect should your Lordship wish to explore it further. All that I wish to submit is that on the face of things it's administrative action, but there may be more to it than that. It's not something that I have considered, and I consequently don't wish to make any firmer submissions on that score.
Certainly, I understand that. It's not a matter raised by the applicant at all, and I'd like to hear Mr. Mpofu in his reply on it later. So just to flag that, Mr. Mpofu and Mr. Sikakane, for whatever relevance it may have.
Yes, God bless you.
Thank you.
Well, Lord, then the last aspect of 194 sub 3 is that the President has no discretion under B in relation to the removal if the Assembly adopts a resolution calling for the person's removal. So in other words, if the 1941 process, which is a thumbnail sketch, is complied with and culminates in the adoption by the Assembly of a resolution calling for that person's removal, the President is obliged to do so. So the formal act of removal is executed by the President, but the decision is the decision of a coordinate branch of government of the state, namely the National Assembly, the primary House of Parliament. And my Lord, as the court will have seen, our discussion of this section is based largely on authorities in which it has been considered. 2 in the Constitutional Court and 1 recently in the High Court in Gauteng. The first case is the United Democratic Movement versus the Speaker, National Assembly 2017 sub 5 SA 300 Constitutional Court. It's in our bundle at page 1124. It's a unanimous judgment of the Constitutional Court in which it was decided that the Speaker has the power to rule that voting on a motion of no confidence in the President, that is regulated by section 102 of the Constitution, can be conducted by secret ballot. Now we refer the court in particular to the following paragraphs of the judgment, and I do not intend to take the court to them because we have extracted what we consider to be the relevant principles. But what I'm saying with respect is that I'm going to say about what one derives from these the principles that we derive are supported by paragraphs 9 and 10, 39 to 47, 57 to 59, 62 to 64, 68 and 69, and 82 to 88 of the Chief Justice's judgment. There is, however, one correction we would like to make to our heads, that is the references in footnotes 16 to 18 of our heads at page 10 are to this judgment, which we call UDM. That's the first important judgment. The second important judgment also concerned the President, but not a vote of no confidence, this time impeachment under section 89(1), the provision to which I took the court. It is economic freedom fighters and others versus the Speaker of the National Assembly and another, 2018 2 SA 571. We referred to it as EFF impeachment. It's in the bundle at page 293. In that case, the majority of the Constitutional Court, the judgment of Jafta J, the main minority judgment being written by the Deputy Chief Justice Zondo, DCJ, held that the National Assembly was obliged to adopt rules defining the grounds on which the President may be removed from office in terms of section 89(1) of the Constitution and regulating the process in the National Assembly for the President's impeachment in terms of that section. We refer the court in particular to the following paragraphs of the judgment of Jafta J for the majority: 130 to 131, 133 to 136, 138 to 139, 164, and then the first set of key paragraphs 170 to 182 and 187 to 196, the second set of key paragraphs. And the court will, if upon reading those paragraphs, it will become abundantly clear that the new rules which have been drafted here to regulate the equivalent process in relation to Chapter 9 institutions, similarly based on what I've referred to as a thumbnail sketch in the Constitution itself, the bare bones. Those new rules were drafted with having close regard, obviously, to the judgment of Jafta J for the majority of the Constitutional Court. And as His Lordship presiding has already indicated, in the period between this judgment and the adoption by the Assembly of the new rules which are impugned in Part B of this present case, the Assembly adopted rules 129 capital A to 129 Q, being the rules regulating the Section 89 process. The third judgment is a judgment in the matter of Institute for Accountability in Southern Africa versus the Public Protector and others, 2020 Volume 2, All South Africa, 469, Gauteng Province, Institute of Accountability. It's at page 552. It's an important case, legally and factually. Factually, because it was an application for orders in which the Institute for Accountability asked the court to declare Advocate Qibani unfit to hold the office of Public Protector on grounds which bear a close resemblance to the charges in Ms. Mazzoni's motion before the National Assembly. The court dismissed it. As regards the grounds, they were based on the findings critical of Advocate Qibani in the SARB v PP1, Absa Bank and PP, the PP SARB CC, DAPP1 and DAPP2. In other words, the self-same judgments to which I've referred earlier. We referred to paragraphs 4 to 18 of His Lordship Mr. Justice Coppin's judgment. As regards the significance of those findings, we referred to paragraph 31 of Coppin J's judgment, to which we return below when addressing the interim interdict which Advocate Qibani is seeking. And as regards Coppin J's reasons for dismissing the Institute's application, chief among them being that the granting of the relief sought would impinge on the National Assembly's power and duty to deal with Ms. Mazzoni's motion, and the granting of the relief would consequently violate the separation of powers, We refer to paragraphs 34 to 53 of Coppinjay's judgment. For the present, suffice it to say the following, and I shall return to this aspect. In that matter, as the report makes clear, the public protector, who is now seeking to interdict the Section 19 process, argued forcefully that the 1944 process, in relation to this similar complaints about her competence and conduct, is the appropriate forum for the adjudication of those complaints and not the court. So we emphasize that the attitude adopted by the public protector in this case, which is one of obstruction, is inconsistent with the attitude adopted by her and by the economic freedom fighters which joined her in that matter, but by her in particular before that court. Turning to the principles that we submit are to be derived from these cases with reference to the Section 194 process, we emphasize 7 points relating to Section 194. And these are borne out by the passages to which I have referred, and where particular passages are important, we do give the references. First of all Chapter 9 institutions, including the public protector, are accountable to the National Assembly. Section 1815 of the Constitution provides the Chapter 9 institutions are accountable to the National Assembly and must report to the National Assembly on their activities and the performance of their functions at least once a year. Now, that accountability is not limited to the reporting referred to. It is a general obligation and a power, duty on the part of, of the Assembly, which correlates obviously to hold them to account. Secondly, Section 194 of the Constitution, which empowers the National Assembly to decide to remove Chapter 9 office bearers from office, is the ultimate accountability ensuring mechanism for all office bearer of Chapter 9 institutions. Those words come from the Chief Justice, UDM paragraph 10, referring, amongst others, to Section 89(1) of the Constitution, which is the presidential equivalent of 194. That case, as I said, it concerned the President, and he referred also to the 2 types of motions of no confidence in the President and the government provided in Section 1022. But the same principle applies to this provision, 194. Thirdly, Section 55(2)(b)(2) of the Constitution obliges the National Assembly to provide for mechanisms to maintain oversight over all organs of state. And we submit that the public protector is an organ of state. Fourth, the rules of the National Assembly are such a mechanism. I referred earlier to Section 57. Section 57(1)(b) empowers the National Assembly to make rules concerning its business. And we see that Section 194 gives it important business in this connection. Fifth, the National Assembly is obliged to adopt rules, and this now refers specifically to 194, which give meaning to the grounds of misconduct, incapacity, and incompetence set out in Section 1941. You'll recall I said to you, or submitted earlier, that certain paragraphs in the EFF impeachment judgment, the judgment of Jafta J, 2018 to SA 577CC, are particularly important. Well, in paragraphs 176 to 178, referring to Section 89 of the Constitution, the Constitutional Court said it is an obligation of the National Assembly to give meaning to those grounds, to clarify them, so that the members of the Assembly having to deal with Section 194 committees will not have to decide for themselves with an obvious, undesirable, potential inconsistency of meaning. So the NA as an institution must predetermine, must define, clarify the meaning of those rules. The second obligation, yes, my lord.
That determination of whether there's a breach of any one of those grounds.
Yes.
That's both a factual and a legal determination, is it?
I agree with that with respect, my lord, yes.
Good. And what in fact is intended that the National Assembly, sorry, we just need to do the recording. sorry about that. So that the Committee of the National Assembly will undertake an inquiry in which both legal and factual determinations are made.
I hesitate to say that for the simple reason that they will undoubtedly have to make factual determinations, and they will have to, having decided what occurred, the facts, they will have to decide whether they fit the bill. In other words, they are, depending on the charges, incapacity, evidence, incapacity, misconduct, or incompetence. My hesitation comes from the following. The Constitutional Court in paragraph 176, 177, and 178, the cited paragraphs that I've given, said that it is undesirable and, in fact, constitutionally impermissible in relation to Section 89(1), similarly worded, for the definitions to be developed ad hoc on a case by case. The legal question has to be predetermined. And may I read to your lordship just the key parts of the judgment? 176. The power. It's in our bundle, my lord, at page
313.
313.
Yes.
The power to remove the president from office is available to the Assembly only if one of the listed grounds is established. One of those grounds is a serious violation of the Constitution or the ordinary law. What qualifies this ground is the word serious. The second ground is serious misconduct, and the third is inability to perform the functions on the office. None of these grounds is defined in the Constitution. It's evident that the drafters left the details relating to these grounds to the Assembly to spell out. But the drafters could not have contemplated that members of the Assembly would individually have to determine what constitutes a serious violation of the law or the Constitution and conduct on the part of the President, which in the first place amounts to misconduct, and whether in the second place such conduct may be characterized as serious misconduct. If this were to be the position, then we would end up with divergent views on what is a serious violation of the Constitution or the law and what amounts to serious misconduct envisaged in the section. And since the determination of these matters falls within the exclusive jurisdiction of the Assembly, it and it alone is entitled to determine them. This means that there must be an institutional, and here's the words I emphasize, predetermination of what a serious violation of the Constitution or the law is. The same must apply to serious misconduct and the inability to perform the function of office. So what the Constitutional Court signaled in relation to these mechanisms, of which there are several in the Constitution, is that it's incumbent on the Assembly institutionally to predetermine, in other words, to define. We've submitted to clarify the terms, give meaning to them. And having done that, that is part of the toolkit which the Assembly takes with it into a process whenever it's initiated. Does that answer your lordship's question? But when it comes to the actual committee, quite clearly findings of fact have to be made. What happened? And then, as in any other adjudicative matter, one must determine whether the facts fit the bill, if I could put that, whether they amount to misconduct, etc., as defined and described in the rules.
I raise it because I want to raise just a broader conceptual issue around this process. And it's something which both yourself and Mr. Budlander will have to perhaps just debate with the court. The role of the public protector is different to the functions of the president. The public protector is both investigative and then, of course, is able to take remedial action, which goes right up to the president, as opposed to the president who doesn't perform such functions. And so, whether she is guilty of misconduct or incompetence or any of the grounds, that is, the Constitution says a finding of that must be made by the National Assembly through its committee. If it's a factual and in part also a legal inquiry, how does that committee perform that function? and it relates to the whole debate around legal representation, which was raised yesterday, in the absence of proper legal representation. But one also gets a sense when one reads the record of the debates that took place when the rules were drafted. I get the sense that at some stage there was a view that the panel, the independent panel, could or should, by some of the parties, that they perhaps arrive at conclusions on these issues. The debate then changed later, and in the panel, the MP said, no, we cannot delegate our functions to the panel. We must make the finding. And that's correct. The finding has to be made by them. But it is the inquiry process prior to the finding that is important. What the independent panel does is to do no more than arrive at a prima facie finding on the evidence. But that evidence, if it is then establishes prima facie the case to be met, a recommendation may go to the National Assembly, who will then send it to the special committee. And that committee then conducts an inquiry and makes a finding. And the question is, and I had asked Mr. Mpofu yesterday, were they happy with the fact that the committee conducts the inquiry and makes the finding? They have no quarrel with that. But it does raise the issue about whether the committee itself should be conducting the inquiry other than making the finding, which could be made on recommendations by an independent panel. So I raised that because it's not an issue raised by the applicant, given that they accept that the committee has to conduct the inquiry. But at the same time, there's this concern that I have about the committee, in fact, conducting the inquiry to establish the veracity, the truthfulness of the factual allegations in respect of the complaint, and then also to make a finding on it. So I refer to some of the issues raised in the committee and how the evolution took place around this very crucial aspect about the role between the committee and the independent panel. It's raised in the debates. It's raised in the discussion paper that the review committee prepared. It seemed that there were different views. And then what I found to be very interesting was that the committee had suggested a number of options, one of which also included whether the independent panel plays a role in the committee process. That wasn't adopted in the final rules. But what it did indicate was that the committee really grappled about the inquiry process itself.
Yes, I respectfully agree with that. There were 4 meetings, and they really tried to come to grips with this difficult job of how to structure a fair and reasonable and effective process for getting to the bottom of these kinds of allegations and reaching ultimately the decision which Section 1941B requires of the committee.
Yes. And the simple question I ask after all of this is that the committee said we will not, or the members said we can't delegate the function of the inquiry to an independent panel. All they can do is to advise us on a prima facie basis. We make the finding. Is there a distinction to be made between the inquiry process by the committee or an independent panel and findings by the committee, which it is required to make in terms of 194?
The answer
And
to
is that
that is
simply a choice of Parliament? Is that simply a choice that neither this court, neither Part B would have to grapple with because it's not in the remit? That's a decision taken by Parliament.
Lord, I think with respect, the answer that you have given is
Yes,
the
thank you.
correct one, and it appears from the second set of important passages in the case to which on which we rely, which is really the handbook for the drafting of rules of this kind. That's paragraphs 187 to 196, which go to the process. The first section deals quite a lot with definition, and we refer you in particular to paragraphs 180 to 82 and 189 to 190. And may I just pick up at paragraphs 178 where I left off, perhaps 178, 179. And I'm just going to read parts of what the court has said, and then I'm going to make certain submissions based on that. 179. For the impeachment process to commence, this is page 313 of the bundle.
Yes.
The Assembly must have determined that one of the listed grounds exists. This is so because those grounds constitute conditions for the President's removal. Removal of the President when none of those grounds is established would not be a removal contemplated in section 89.1. Equally, a process for removal of the President when none of those grounds exists would amount to a process not authorized by the section. That last sentence is very important because it leads to the next statement. Therefore, any process for removing the President from office must be preceded by a preliminary inquiry, during which the Assembly determines that listed grounds exists. The form which this preliminary inquiry may take depends entirely upon the Assembly. It may be an investigation or some other form of inquiry. It is also up to the Assembly to decide whether the President must be afforded a hearing at the preliminary stage. Since the power to remove is institutional, the Assembly must decide and facilitate the initiation of the preliminary stage. It may well be that each member of the Assembly has a right to initiate the preliminary process. Even so, the Assembly must facilitate steps to be taken in this regard and a process to be followed, not only at a preliminary stage, but also at the stage of the actual impeachment, up to the final stage of voting on whether the President should be removed from office, so as to determine whether the removal is supported by the necessary two-thirds majority. Then 182, first line. Without rules defining the entire process, it's impossible to implement section 89. Could I then ask you to jump to 187? In opposing the claim, the Assembly failed to put in place, imposing the claim that the Assembly failed to put in place mechanisms for deciding impeachment proceedings, the acting Speaker called in aid Rule 253, which governs the establishment of ad hoc subcommittees. He said a member of the Assembly may request that an impeachment matter be referred to an ad hoc committee established in terms of the rule. This rule, he continued, requires that the Assembly to specify the task assigned to the committee, which may include conducting an inquiry or investigation and reporting or recommending to the Assembly on steps to be taken pursuant to its findings. Then 188. Significantly, the acting Speaker does not tell us the meaning assigned to serious by the Assembly, nor does he say what would happen if each member of the ad hoc committee attaches a meaning to the crucial word which is different from the interpretation of other members. That was the issue dealt with earlier about definition. All that he says is that the committee's recommendation will have to state whether the breach is serious enough to warrant the President's removal. Then back to procedure more, he says, on this approach, it's the initiator of the process who determines whether the President has committed a serious misconduct or a serious violation of the Constitution or the law. If the initiator holds that opinion, he or she may request that an ad hoc committee be established to investigate and recommend to the Assembly that the President be removed from office. This process lacks a sifting mechanism, which would determine whether there is a case for the President to answer. But over and above that, the ad hoc committee process does not have a procedure for the committee to follow in carrying out its task. And then he goes on to criticize the rules. And 194, the ad hoc committee, the second sentence, do not constitute a mechanism contemplated in section 89.1 for the reasons set out in this judgment. 196. For this end result, I conclude that Section 89.1 implicitly imposes an obligation on the Assembly to make rules specially tailored for an impeachment process contemplated in that section. And I hold that the Assembly has, in breach of Section 89.1, failed to make rules regulating the impeachment process envisaged in that section. So why I've taken you through all of this, my Lord, is the following. It's clear that what the court held is, firstly, that there have to be rules which regulate the entire process. And these rules must describe them, firstly, the manner in which it must be initiated. Secondly, it must create a sifting mechanism to determine whether the Chapter 9 office bearer has a case to answer. Thirdly, it must regulate the proceedings of the National Assembly Committee, which must consider and decide whether a Chapter 9 office bearer is incapable or is incompetent or has misconducted himself or herself. We know what these rules have done. They have, firstly, I've referred you to the rule requiring a substantive motion. 129 has to set out charges which, on the face of things, if proved, will constitute misconduct as defined, etc., supported by evidence which is compliant with the Constitution and the law and so on. I'll get to the details on those later on. So there's an initial, and the Speaker has to assess that under 129S. That's an initial threshold question, so that this whole process doesn't start with a frivolous or vexatious or off-the-mark complaint. In other words, what the Speaker's job is really akin to assessing whether the claim is excipiable. Because what you have to do is you have to set out the charges, they have to relate to the person in question, they have to be substantiated by evidence. But what she will do is she will look at the end of the day and say, well, if these charges, the particulars here that are alleged are proved, will they amount to serious misconduct, or to misconduct as defined, or to incompetence as defined, or incapacity as defined? And if she says they don't, then she will rule that she will not accept the motion. She will say it's not in order under 129S. If the person passes that threshold, as Ms. Mazzoni did on the 26th of February in relation to the current motion, the next step is for a panel of legal specialists, experienced lawyers, to be appointed. One of whom can be a judge. There's a point taken about that which we will deal with briefly towards the end of our submissions. Their job is a different one. It's not the exception job so much as to assess the case in the round to determine whether there is a prima facie case to meet. And what I would emphasize here is that the key words here is to determine whether there's prima facie evidence to show that the holder of the public office committed misconduct, is incapacitated, or is incompetent. So the focus there is on the evidence, whether there's prima facie evidence to show. The initial, if I can call it the exception type assessment by the Speaker, is the motion must be limited to a clearly formulated and substantiated charge on grounds specified in Section 194, which must prima facie show that the holder of the public office. So the grounds specified must prima facie show that the holder committed misconduct, is incapacitated, or incompetent. And 129S requires the Speaker empowers her to consult with the member to ensure the motion is compliant with the criteria set out. And 129T says if she finds the motion is in order, she must then refer it. So one has a double sifting mechanism, initially at the level of the Speaker, and secondly in the independent panel. Now, in the independent panel, there is an obligation on it to provide the holder of the public office with a reasonable opportunity to respond in writing to all the relevant allegations. And it's not oral, it's in writing, but the public office bearer gets the opportunity at that stage already to put a stop to it if, in his or her opinion, there isn't a case to answer. This panel doesn't decide anything. It makes recommendations to the Assembly in a report, and the Assembly has to consider that, 129Z, with due urgency given its program. And it's only once that double sifting mechanism has been undertaken that the Assembly will decide whether or not a Section 194 inquiry be proceeded with. It may decide not to do so, and that's the end of the matter. One never gets to the committee, in other words, referred to in 194(1)(b). If that committee is constituted, rules relating to that, then 129 AD requires the committee to conduct the inquiry to establish the veracity of the charges. That's its job, to establish the veracity of the charges. And it must do so in a reasonable and procedurally fair manner, and it must give the holder of the public office the right to be heard in his or her own defense and to be assisted by a legal practitioner. But the legal practitioner may not speak. Just to get ahead a little bit here.
Just on that point.
Yes.
The inquiry to establish the veracity of the charges.
Yes.
What exactly will that entail? Would it entail that the committee assembles, there's all the charges, there's the evidence, and they will determine a procedure for dealing with that?
Yes.
But it's an inquiry procedure, so evidence will have to be led.
Not necessarily.
Evidence about something. What does the holder of the public officer do in that process? Does he or she just sit there, listen? Do they have the chance to ask questions of clarity? What exactly takes place in that committee?
It will depend on the facts and circumstances of every case. So there'll be, each one will require a different process. The starting point is that the inquiry must be conducted in a reasonable and procedurally fair manner within a reasonable time frame. Let's contrast two types of cases. Let's take a case where it is common cause that the Chapter 9 institution has been convicted of a serious offence involving dishonesty, as happened in Laga's case. It's not a dispute. The question, an interesting question in such a case, is whether that conviction stands, or whether the committee needs to inquire into the res gestae to decide whether indeed the person was convicted, did commit theft, notwithstanding the conviction. It seems to me, on a reading of 194, that the committee must decide for itself those facts. However, it may have before it the record of the criminal proceedings, including the evidence given by witnesses for the prosecution and for the defense. And it seems to me entirely appropriate for the committee to say to the Chapter 9 office bearer, this is the evidence. May we have regard to this evidence given on both sides of the question? And let's assume for the moment that the office bearer says yes, and then to say, is there anything that you wish to add in relation to this matter? Any other witnesses that you wish to call, or any further testimony that you wish to give yourself? Depending on the attitude adopted by the office bearer, one might have a longer or a shorter inquiry. Another relevant question in application proceedings, and you know that in this particular matter, the DA has appended as evidence not just the judgments of the courts, but also what it considers to be the relevant papers in all of the cases in question. In other words, the affidavits in which consequently led to findings such as those which I read out earlier by the Constitutional Court. It would be entirely appropriate, I submit, for the committee to say to the public protector, if it ever goes that far, did you make this affidavit in which you said that you relied on the evidence of economics experts? It would be entirely appropriate for the committee to ask the public protector, did you in fact rely on the evidence of economics experts? and let's assume for the moment that she chooses to answer that question and answers no, it would be entirely appropriate for the committee to ask her, why then did you make an affidavit saying you had done so when you didn't? So one needn't proceed proceed as we lawyers unfortunately often tend to do. And I'm speaking for myself now, my lord, not the court. You know, we think of things like this. I start thinking about Section 112 of the Criminal Procedure Act and 115 and so on and so forth, and call your first witness. Impeachment proceedings are ultimately goal-oriented activity. The one thing about them is that they're conducted by politicians, and that's not by accident, it's by design, the constitutional design, not by lawyers. That doesn't mean they do not have a job to conduct a rational inquiry. That's the ultimate touchstone imposed for all exercises of public power. It has to be substantively and procedurally rational. In this particular case, the National Assembly has gone further and has said that.
Just on the issue about what happens in the committee, where there are disputes of fact,
Yes.
how are they resolved?
All decisions taken by the committee are 129 AE, assuming there's a quorum present, will be voted on ultimately by the committee. And I don't wish to get into too much detail, but 129 AD4 also gives to the committee the power applicable to parliamentary committees provided in the constitution applicable law and the rules, and those include the powers to subpoena people and to require that they turn up, produce documents, answer questions and the like. So they have muscular powers, but it ultimately, my lord, it will depend on the case. One might, at the one extent of the...
It's precisely these muscular powers that may be a bone of contention, because the public officer sits either alone or with lawyers at long end. How do they protect themselves in these processes? And two, how do they deal with the disputes of fact where witnesses are called which they are not able, possibly by lack of skill, to cross-examine?
The answer to that is that they are entitled to legal assistance from a legal practitioner or other expert of their choice. There's no limit placed on that assistance, except that the practitioner may not participate in the committee. In other words, the practitioner may not speak for the person or speak in the committee. The Chapter 9 office bearer, himself or herself, has to do the talking, whether it's to the committee making submissions or dealing with the witnesses against him or her. And why is that? It is because, as the Chief Justice said in the UDM case, this is the ultimate accountability ensuring mechanism. This is about the National Assembly holding someone to account, not necessarily about removing them. They may ultimately decide, and notwithstanding, let's assume for the moment of finding not to remove the person because there are political considerations there. It's not simply a question of you are removed if the committee finds that you are incompetent, incapable, or have misconducted yourself. Subsection C of 194.1 is very important. One has to take the question to the premier legislative body in our country, the National Assembly, and a certain majority has to vote on the question, having considered the obviously report of the committee. So that is a political question, and I'm not by making that submission suggesting anything untoward about that, but there are issues of statecraft of the national importance which also come into play. What is quite clear from the constitutional structure and from these rules, that this is a very serious matter indeed. And there is the threshold to screen out, as required by the Constitution, motions of this kind which should not trouble the National Assembly, and particularly the Chapter 9 office bearer beyond, say, the first screening stage. But once one is...
Can I come back to the issue of legal representation since it's now been raised?
Yes.
Why would the public office bearer not be able to have a lawyer who is able to assist him or her in a process of seeking clarity from witnesses, or whether it's cross-examination, other than the person themselves having to testify or to make a statement or to answer questions? The lawyer doesn't substitute the person in that process for being of accountability. What the lawyer does is to provide a particular set of skills and assistance to the person in being able to assist the committee in establishing the truth of the allegations, the veracity as the rule says.
Yes.
Why is that not allowed?
And the answer is the answer that I've already given. What is happening here is a office bearer has been charged, let's say, with misconduct in relation to something, in other words, that he or she has done, and is being called to account. It is for the office bearer to account, not a person speaking on her behalf. The accountability is direct between the office bearer and the National Assembly. And that is the reason which is given in the papers for this.
I accept that she has to, or he has to account. But there is a skill required with regard to the establishment of allegations against him or her. And that skill, our law recognizes as cross-examination has been the ultimate weapon of being able to find the truth. That's what trials are all about. And here, given the serious consequence that flows or may flow, the loss of a job and the loss of reputation, the impact on the constitutional order, allegations that are made in that inquiry process can and should be tested. And why should they not be tested with the assistance of legal skill? I can understand that parliamentary committees have an aversion to having lawyers come to the processes and draw out processes endlessly, as often happens. But here is an inquiry that could lead to very serious consequences, not only for the person concerned, but also for generally the constitutional order. And why is there this aversion to legal skill being allowed to test the evidence?
The reason comes back to personal accountability, and obviously the converse is avoiding the over-legalization or judicialization of this process. This is not a trial in a court where a person stands accused of a crime and may be convicted and sentenced for that crime. It is an assessment by the body which appointed someone on the basis that they were fit and proper and met the other requirements in Section 193 of the Constitution, whether they have misconducted themselves, are incompetent, are incapable of performing the job or the constitutional task which they have been assigned. It is a matter which the Constitution has it's not just a question of the National Assembly being the body which decides this question, a committee of the Assembly, not a court. It goes further than that. On the authority of UDM, it is for the Assembly itself to decide how best to set about this. And with the greatest respect, my Lord, and I, having had a relatively long career in the law myself, I tend also to think that our way of doing things is, one can quote many judgments and learned authors about the value of cross-examination in uncovering the truth. But these are politicians deciding for themselves, as they are entitled to do, how best to set about conducting an inquiry of this kind. Many members, in fact, I would be surprised if a majority of the members were lawyers. It's not a requirement that one is and has to be a lawyer to decide. The unusual thing about a committee like this is that it's comprised of people who are not required to be lawyers. All of them may be lay people, but all of them are Constitutional Assembly has decided, all members in such a committee, they must decide. It's like a trial, if one looked at it that way, without a judge directing the jury. Why is that so? Well, it's a matter between the Assembly and the Chapter 9 office bearer. And it's a vitally important point, because what it ultimately means is that the standard that applies here is not the standard which applies in a criminal trial. It is not even the standard which applies in an administrative tribunal. I shall deal with this in a little more detail later. This is not administrative action. This is the performance of a constitutional function by the National Assembly. This is not something of an administrative nature tied up with the day-to-day functioning of the bureaucracy. The decision which is taken here is not of an administrative nature, and I shall refer you to the Grays Marine case in that connection. Therefore, the applicable standard is rationality, substantive and procedural rationality. And when it comes to assessing, and this relates to Part B, my lord, the strength of this particular complaint, the one thing that is absolutely clear, and we're talking about the rationality question on our rationality jurisprudence, is that the question whether in the mind of the court assessing rationality there's a different or a better way of doing things is not a relevant question. The question is simply whether the means chosen are rationally related to the end sought to be achieved, and procedural rationality-wise, whether the means chosen, and this is usually done retroactively looking at particular decisions, resulted in all the relevant material being taken into account. And I shall deal with procedural rationality in the context of accountability later on. My lord, if one applies those, and that's well-established jurisprudence to these rules, and having regard to what your lordship knows about the anxious process of considering various options that went into them, there is a very slim prospect indeed of a court being able to find legitimately, in the sense that it will withstand ultimate scrutiny by the Constitutional Court, that this particular aspect aimed at avoiding the kind of situation that we saw in America earlier this year, where there was a so-called impeachment trial in the Senate. And what was striking to me is that the person whose impeachment was sought never uttered a word in those proceedings. Our National Assembly has opted for a different model of accountability. You can be assisted by a lawyer, save that you yourself have to speak. And I have to say, in the case of the public protector, and this goes to the question of her standing to attack these rules on grounds in relation to other Chapter 9 office bearers, the requirements for appointment of public protector, obviously, as your lordship alluded to when referring to the nature of her work, require forensic skills of a high order. Much of the criticism directed against her in the judgments at the competence level, I leave aside questions relating to her probity, go to whether or not she's exhibited those skills, has the necessary skills, or has deployed them in the conduct of her work. She's not a hapless accused, as we said in our written submissions. Someone legally trained. I refer to her throughout as advocate in Qibani. She's been an advocate for many years. She herself will not significantly be disadvantaged, and the benefit will be is that we'll avoid the spectacle that we saw in America earlier this year, where the person lawyered up never utters a word.
Good. Well, I've taken you on a tangent on what I thought was an important concern that the court had to debate with you. So,
yes, my lord. No, I appreciate it.
Do you want to get back to your notes?
Yes, I was at page 16, and I've dealt with the 2 points in paragraph 17, derived from the EFF impeachment case, paragraphs 176 and following, about adopting rules giving meaning to the grounds of misconduct and regulating the entire process. I'm now points 18, page 17. If at the end of this process in the Assembly decides by the majority prescribed by 194.2, in other words, the 2/3 of its members in the case of the Public Protector and the Auditor General, that a Chapter 9 office bearer must be removed, Section 1943 obliges the President to remove the person from office, and consequently, the principle of the separation of powers requires that this court respect the fact that the power to determine the fitness of a person to continue to hold the office of Public Protector has been assigned by the Constitution to the Assembly and the President. This means that the court should not interfere in the process of the Assembly unless it is necessary to ensure that it acts within the law and fulfills its constitutional obligations. And those are pertinent findings made with respect correctly by Justice Qibani. May I just say a word about deference? The deference it derives from the separation of powers. And I wish to make it absolutely plain, and it relates to the debate that I've just had with your lordship as well on behalf of my client, the Speaker of the National Assembly. Our position is not that there is some kind of immunity here which the court has to put up with irrational or unlawful action. What it amounts to is that where by constitutional design a particular function is given to a coordinate branch of government, in this case the legislative branch, that the court must be careful in all respects when engaging with litigation of this kind, whether it comes to scrutinizing the particular mechanism which the assemblies has created, or to, in review proceedings, the application of the mechanism, in other words, the actual process in a particular impeachment inquiry. But just be mindful of the fact that one is dealing here with a job which has been assigned to someone else. In the law of years gone by, or the legal terminology of years gone by, there isn't an appeal to this court. The danger of that is, of course, that if the court were to assume a function of assessing for itself whether the rules are right, in other words, whether it would have prepared the same kind of rules or applied them in the same way, that one then is really transferring the ultimate locus of the authority from the one branch to the other. And that's why it's so important when one comes to assessing the grounds, particular grounds raised here, that we get it right as to what the standards are. And I will be submitting in a moment that my learned friends have impermissibly, with respect, sought to import large swathes of our administrative law relating to administrative action into this process, and then to say that this process, which is a process in the legislature with this very strong political element, and that's the voting element, doesn't measure up to what is required of the administration. Well, Lord, the next topic then is the new rules themselves. Now, in our heads at paragraph 71 to 96, we describe the 19 steps for the impeachment process under section 194 in the new rules. We shan't repeat the details of that description. It seems that the parties are ad idem, that the description, which for convenience, as you know, we've broken up into 17 separate steps, is accurate. There's no debate about the attempt that we've made to render in a sequential way the process. What we shall do is limit our oral submissions on this aspect to emphasizing two key features of the rules. The first is in line with the parts of the impeachment judgment that I've just referred to, paragraphs 176 to 178. The rules define the grounds of misconduct, incapacity and incompetence set out in section 194. And in that regard, I would ask the court simply to open the Constitution at 194, and one sees misconduct, incapacity, incompetence, and then look at the first page of the relevant section, which is page 143 of the record, and one sees, for instance, in relation to, say, misconduct, it means the intentional or gross negligent failure to meet the standard of behavior or conduct expected of a holder of public office. So, an interesting I find it interesting when working this case up, is that although the Constitution here talks about misconduct, and elsewhere we know it talks about serious misconduct in the case of the president, and in the cases of a judge, it talks about gross misconduct. What was decided here is really to describe it as very serious. It's intentional failure to meet the standard of behavior or conduct expected of a holder of public office, or gross negligent failure. So what has happened here is that element of intention or an objective standard negligence, but of a higher standard, gross negligence has been introduced, and the yardstick is there, the standard of behavior or conduct expected of a holder of public office. Now that comes back to the question which your lordship raised, is that will depend on the facts, and it will require an application of this definition to the facts. And
Mr. Breitenbach, in the authorities they refer to willful, and that's probably just synonymous for intentional.
yes. Yeah,
And so
willful. Yes.
Is there a difference? Because the authorities refer to willful and gross negligence, and that would have been the inspiration for intentional.
Could well be. Willfulness is always intentional. Willfulness might have an added element as well, which is an element of obtuseness involved. So in contempt cases, contempt of court cases, the standard is willfulness, and it's intentional, but probably not dolus eventualis or one of those forms of intention. So that's we have the definitions in the rules. The two relevant ones are incompetence and misconduct. There was quite a lot said about incapacity yesterday, my learned friend. Your lordship grappled with him about that. Later on, I shall deal briefly with your lordship's point about the charges, but also with a related point concerning standing. The leading case is giant concerts, and I shall just briefly touch on that. But the key definitions here are incompetence and misconduct, and the point that I wish to make is both of them have they have a high threshold, higher than what the dictionary definition. Intentional and gross negligent. In the case of incompetence, demonstrated and sustained lack. So it's true that the definition of incompetence is not exhaustive. It's an includes definition as opposed to misconduct, which is a means one. But it's a demonstrated and sustained lack of knowledge to carry out and ability and skills to perform his or her duties effectively and efficiently. And those A and B are conjunctive. Knowledge and ability and skill to perform. So there are many grounds upon which a office bearer can defend themselves based solely on the definitions. The second point that we wish to make, and I'm returning to the note at page 18, is that in line with the paragraphs of the impeachment case to which I've referred relating to regulating the entire process, we see it deals with how the process must be initiated. That's Rule 129R, a notice of substantive motion containing a clearly formulated and substantive charge or charges and attaching all the evidence relied on. There are 2 sifting mechanisms to determine whether the Chapter 9 office bearer has a case to answer, namely an initial assessment by the Speaker whether the motion is compliant with the criteria, and a subsequent assessment by the 3-person independent panel of whether there's prima facie evidence to show that the incumbent has committed the misconduct or is incompetent or incapacitated for the reasons alleged in the motion. And after the receipt of the panel's recommendations, there has to be an initial decision by the NA as to whether or not to proceed with an inquiry in terms of Section 194. The rules then regulate the conduct of the inquiry by the specially constituted committee with a view to its making the Section 1941B finding as to whether the incumbent has indeed committed the misconduct or is incompetent or incapacity for the reasons alleged in the motion. And after that, the committee must report and make recommendations, and if it recommends that the incumbent be removed, there's a voting on that question. So the rules we submit fit the bill. They comply with 194 and with the judgment in the EFF impeachment case as adapted and applied to Section 194. That brings me to...
Let's just pause for a second and deal with the critique raised by the applicant that the motion that is accepted or approved by the Speaker, they contend that that's really a substantive question that the Speaker inquires into, and that at that stage they would have been entitled to be heard on it, and as they point out, that they would have raised the issue of retrospectivity and probably a whole host of other issues with regard to the charges. Do you want to deal with that, please?
Yes, my lord. It's the first thing is that there's no right there's no right extrinsic to the rules to be heard at this initial stage, because in order for that right to manifest, one would have to say it would be procedurally irrational not to allow the public office bearer to participate at the screening stage. In other words, at the stage when it is determined whether she has a case to answer. We accept unreservedly that if a case is proffered, in other words, it moves to the 194(1)B committee, then obviously she has to participate for this simple reason. It is the ultimate accountability ensuring mechanism, and you cannot achieve that purpose without hearing the person. So we have no hesitation in accepting that the rules, that the Constitution requires that the person be given an opportunity to participate in the 194(1)B committee. Non-constat that the person needs to be given the opportunity to participate at the screening stage, or more specifically, to focus it on our learned friends' submissions, at any particular juncture in the screening stage. As a matter of fact, however, when adopting these rules, the National Assembly did decide to give the office bearer an opportunity to participate at the screening stage, and that is before the independent panel. And what that means is that the public office bearer must be given the motion, must be given the evidence, and any other information which is available to the panel. In other words, because the panel is also entitled, as you know, to, at its sole discretion, to afford any member an opportunity to place relevant written or recorded information before it within a specified time frame. So once it's received the motion and the substantiating evidence, and if it exercises that power, it must without delay provide the holder with copies of all information available to the panel relating to the assessment, and then it must provide the holder of the public office with a reasonable opportunity to respond in writing to all relevant allegations made against him or her. Now that response may include, for instance, a contention that the misconduct complained of occurred before the adoption of these rules, and the rules do not apply retrospectively. That's a legal question, but that's certainly encompassed by the response. Yes, it means that it has implicit within it that the Speaker shouldn't have accepted the motion, because she too approached the matter on the basis, or she did approach the matter on the basis that the rules regulate any process after their adoption, regardless of whether the conduct in question or complained of preceded or post-dated the adoption of the rules in December. But the point is, there's no restriction whatsoever on the points which can be taken on behalf or by the holder of the public office in the written response. So, with respect, the complaint of procedural unfairness, in any event inapposite in this context, because it's a question of rationality, falls flat. Because before the Assembly decides whether to proceed to the 194 inquiry, this question and any others will be considered and reported on by the independent panel. Of course, ultimately, my Lord, and let's assume for the moment that this process runs its course adverse to Advocate Qibani, and it's found, for instance, that the conduct mentioned by the justices of the Constitutional Court majority in the case that I referred to constitutes misconduct, and the requisite majority of the National Assembly decides that she be removed from office. If she is right that the rules, the 194 process as a whole, does not apply to conduct which predated the 3rd of December last year, then if she's found to be right in ensuing legal proceedings, she'll be reinstated. We, of course, contend respectfully that that is an absurd proposition. It has as its consequences that no matter what a Chapter 9 office bearer didn't do before the 3rd of December, there can never be any proceedings for that person's impeachment just because rules regulating the 1941 process were not in place. That, we submit, is an absurd interpretation of the Constitution as interpreted and applied by the Constitutional Court in the EFF impeachment case. But for present purposes, it suffices to say that if the point is a good one, well, then she will be vindicated in review proceedings. If necessary, those proceedings can be brought urgently, prosecuted urgently, and decided urgently. Perhaps even a direct access application to the Constitutional Court would be entertained if there was such a travesty of that kind. But we submit that the point itself lacks any merit, because it could never be that from 1997, the 4th of February, when this Constitution came into force, that all public protectors and others have been immunized against impeachment proceedings just because Parliament hasn't, until recently, adopted specific rules regulating the process.
Can I just raise the point again about what is described as the arbitrariness of the Speaker's conduct when she did provide the applicant with a copy of the charges and the evidence. Yes. The argument is that was rather arbitrary. There's no guidelines, and she did that no more than on the whim.
Well, my Lord, that's a hard road to hoe for the applicant, because the Speaker explains in her affidavit, and it's dealt with in our heads of argument, why she made the information available when she did. And it was that she received this motion. It was now very detailed. There was a very large quantity of supporting evidence attached to it. She knew that the public protector would be entitled to and would receive the information from the independent panel when the proceedings of that panel commenced. But that panel operates in a tight time frame, 30 days. And she wanted to give the public protector as much time as practically possible to prepare. And so on the very same day that she approved the motion on the 26th of February, she made the information available to the public protector. She's now had it for many months and is no doubt well acquainted with the charges against her. And should the matter proceed to the independent panel, in other words, if it is appointed, she will doubtless have already prepared, unless she unwisely decided to bank everything on a positive outcome in this particular matter. She will have prepared her submissions, her response under 129X1C3. There's no question on the facts of this case, I would submit, of there being any irrational conduct on the part of the speaker, and certainly even if fairness were to apply, sort of a generalized standard of fairness, she's been treated more than fairly. She's had many months now to gear up for her first opportunity to participate in this process. Lord, may I deal with the legal principles which govern the application for an interim interdict, which we submit are vitally important, and on which you heard some submissions yesterday, which with respect don't accord with the applicable law in certain important respects. And there seemed to me to be two big submissions that were made yesterday. They were weaved into my learned friend, Mr. Mpofu's argument. The one is that outer doesn't apply if there are constitutional challenges in anticipation. In other words, if the Part B or the lite to which this is pendente is going to entail a constitutional challenge. And the second is that outer doesn't apply where there are allegations as opposed to proof of mala fides, etc. And I submit, for reasons which will become apparent when I deal with the cases, that neither of those contentions is sustainable. Now, we deal with this issue in our heads of argument, the legal principles governing the application for an interim interdict, in two places. The first is paragraphs 131 to 146, and the second is 219 to 243. As the court will remember, in between, we deal with the merits of the 10 grounds of attack, following on the dealing with prima facie right. What we've decided for the purposes of today's submissions is to just deal first up front with the legal principles and apply them to the facts when they come to the discretionary elements of the decision. In other words, the non-prima facie right ones, and then to deal with the actual challenges themselves with specific reference to what was submitted yesterday. Now, as the court will have seen, our discussion of this issue is based largely on 7 authorities. The first is the outer case, National Treasury versus Opposition to Urban Tolling Alliance, 2012 6 SA 223 Constitutional Court. It's in the bundle at page 912. And it was an interim interdict pending a judicial review of the declaration of the Gauteng highways as upgraded as toll roads. The second case is the City of Qibani Metropolitan Municipality versus AfriForum in another case. That's 2016 6 SA 279 Constitutional Court. We'll call it AfriForum. It's at page 1103 of the bundle. Now, that case was an interim interdict pending a judicial review of a municipal council decisions to change apartheid-era street names, and it was based on allegations of inadequate public consultation and, importantly, an infringement of the right of a cultural, linguistic, or religious community in section 31(1)A of the Constitution. And I would just refer the court to the discussion in the majority judgment of the Chief Justice under the heading Prima Facie Right, which starts at paragraph 50. It's on page 1110, and I read simply the start of that. AfriForum relies partly on Section 31 of the Constitution as the prima facie right sought to be protected with a restraining order pending the finalization of the review proceedings. Fortunately, as the right is only required to be prima facie, though open to some doubt, it need not be here. Otherwise, there might have been a problem, given what Section 31 right entails, for it basically affirms the enjoyment of a cultural, linguistic, or religious right of a community and its members, provided that the right is exercised consistently with all the other provisions in the Bill of Rights. And so the court continues. So the simple point that I wish to make here is that AfriForum is an example of a case where what was intended was a constitutional challenge. Now, Qibani, the third case on which we rely, Qibani and others versus Mbete, Speaker of National Assembly of Parliament of the Republic, another was an interim interdict pending wide-ranging proceedings. There was obviously an attempt in that case to stop the Speaker herself from presiding because of alleged partisan behavior on her side. It's at page 1083. But as far as the wide-ranging nature of the proceedings that were envisaged and did eventuate are concerned, we refer you to the judgment of this court in those wide-ranging proceedings, Qibani and others versus the Speaker of the National Assembly and others, 2016 1 SA 534 Western Cape Constitution, Western Cape Court, sorry. And as your Lordship will see, one of the big points made in that case, relief sought there, was a declaration that NA Rule 102A was inconsistent with Section 102.2 of the Constitution. Now, that rule was the rule which was adopted by the National Assembly to regulate the motion of no confidence procedure in Section 102.2 following the judgment of the Constitutional Court in a case called Mazibuko, which, as far as I know, was the first case in which the Constitutional Court held that it's incumbent on the National Assembly to adopt rules regulating one of these accountability type processes. So there was a constitutional challenge that was in the offing. It's an interesting, and you'll see this from the judgment in the interim interdict case, the Qibani one at 1083, that by the time the interim interdict proceedings had been brought, the applicants had tried and failed to get direct access to the Constitutional Court to have all their problems dealt with by that court as the court of first and final instance. The fourth case is another judgment of this court. It's Mahlaloga and the Speaker of the National Assembly, 2019 ZAWCHC 31. In other words, it's unreported, but available on SAFLI. It's in the bundle at page 820. And that was an interim interdict pending the final outcome of criminal proceedings against the applicant, on which NA proceedings for his removal from the office of chairperson of the ICASA, Independent Communications Authority of South Africa, which is the Chapter 9 institution envisaged by Section 192 of the Constitution, were based. He'd been convicted, but there was an attempt to appeal, which was still pending. The fifth is Jiba and the President of the Republic and others, 2019 for all South Africa, 742 Western Cape. We refer to it as Jiba. It's at page 573 of the bundle, and it's an interim interdict pending wide-ranging proceedings, including a constitutional challenge to Section 12.6 of the National Prosecuting Authority Act. So there again, there was a constitutional challenge in the offing. Then you have EFF, Economic Freedom Fighters v. Gordon and others, Public Protector and another v. Gordon and another, unreported as yet, 2020 ZACC 10. We call that EFF interim interdict. It's another judgment of the Constitutional Court. It's at page 247 of the bundle. And that was an interim interdict pending judicial review of the remedial action in a report by the Public Protector. And the last is National Commissioner of Police and another very recent judgment of the SCA versus Gun Owners Association of South Africa, 2020 ZASCA 88. We call it GOZA. It's at page 851 of the bundle, and it was an interim interdict pending judicial review of a decision taken under the Firearms Control Act 60 of 2000. Incidentally, in that case, the court was deprecated the infringement of the separation of powers. The judge who decided it happened to be, as far as I can see, the same person who decided the interim interdict that was overturned in the outer matter. So outer is the starting point for this jurisprudence. And paragraphs 41 to 45, the Constitutional Court affirmed that the long-standing test for claiming the extraordinary remedy of an interim interdict restraining the exercise of a public power remains good law. The applicant must establish, firstly, a prima facie right, even if open to some doubt. Secondly, a reasonable apprehension of irreparable and imminent harm to the right if an interdict isn't granted. Thirdly, the balance of convenience must favour the grant of an interdict. And fourthly, the applicant must have no other remedy. Meeting these requirements, however, does not oblige a court to grant the remedy, which is ultimately subject to the court's overriding discretion. Your Lordship referred yesterday to these proceedings as being discretionary with respect correctly. The authority for that is the old case of Ericsson Motors, Velcom Limited and Protea Motors Warrington, 733 SA 6858 at 691 C to G, which is in the bundle at page 344. However, as the Constitutional Court explained in outer, even before the advent of our Constitution in the mid-1990s, that's our democratic Constitution, at common law, the court will not readily grant an interdict restraining the exercise of a statutory power and will only do so in exceptional cases where a strong case is made out. That point is made with reference, obviously, to Setlogelo and Gould's cases. And what the court added, the test now to be applied must be applied cognizant of the normative scheme and democratic principles which underpin the Constitution. And this means that when a court considers whether to grant such an interdict, it must do so in line with the principle of the separation of powers and in a way that promotes the object, spirit, and purport of the Constitution. As a result, the Concourt held in the outer case that in proceedings where well ahead of the final adjudication of the main case, which is what's happening here, we haven't seen the supplementary affidavit yet of the applicant, let alone answers, replies, heads of argument, etc. A litigant seeks an interim interdict that would impinge on the separation of powers were it to be granted. The interdict may be granted only, and these are the two clear points, in the clearest of cases and after careful consideration of the harm to the separation of powers that will ensue. And may I just pause there for a moment? I'm going to quote from the relevant cases because the jurisprudence becomes more refined and subtle in some of the later judgments, including the judgments of this court. But I wish to make the following base submissions. Where I refer here to the clearest of cases, that is not limited to the prima facie right requirement. It's clear from the authorities that I'll be quoting that the clearest of cases means the clearest of cases for an interim interdict. In other words, at the end of it all, the court needs to ask itself, is this one of those exceptional cases where it's abundantly clear that an interim interdict has to be granted? That's the first point. And it's on the round, looking at everything. And the second point is that what the Constitutional Court has said, and this was the admonition of the High Court in outer, and it has followed right the way through, as I say, to gun owners in the SCA now, is that the court has to carefully consider the harm to the separation of powers that will ensue. So the injunction is, the one thing that has to be looked at particularly carefully is the separation of powers harm. An interesting feature of the jurisprudence, as we shall see in relation to the prima facie right requirement, is that while on the one hand the court says the High Court, considering a case like this one, must be satisfied that a very clear, almost approaching a clear right is established. In other words, it edges towards the final interdict test. On the other hand, the court needn't engage. It's clear, both from outer but also from a more recent judgment, EFF, the court doesn't have to engage in the merits as if it is the court dealing with the Part B. In EFF, Justice Kampepe talks about a peak, and we submit that is important. What the court needs to do is not, because it would just make cases like this absolutely impossible. Because although this is a big case involving matters of high constitutional import, many cases of this kind, where someone is seeking to restrain a public office bearer or officer from organ of state from carrying out a statutory power or duty, those cases are not of the same magnitude. And what the court says, you don't have to get ahead of the Part B proceedings and actually decide them. So I'm going to just deal now with reference to these two elements, the clearest of cases and after careful consideration to the harm. Sometimes the judgments deal with two conjunction, but I'll just deal with some of the key passages. In the EFF interim interdict case, which, as the court knows, is very recent, that's a 2020 decision. If you'll bear with me for a moment, the date on which it was decided was the 29th of May this year. So after these proceedings had been instituted. The court said in paragraph 42 at page 266 of the bundle, and I quote, "Before a court may grant an interim interdict, it must be satisfied that the applicant for an interdict has good prospects of success in the main review. The claim for a review must be based on strong grounds which are likely to succeed. This requires the court adjudicating the indication to peek into the grounds of review raised in the main review application and assess their strength. It's only if a court is convinced that the review is likely to succeed that it may appropriately grant the interim interdict. The rationale is that an interdict which prevents a functionary from exercising public power conferred on it impacts on the separation of powers and therefore should only be granted in exceptional circumstances." So it's an extremely high threshold. The court must peak, but one really has to meet a high standard if you're in the position of the applicant in this matter. As far as B is concerned, the careful consideration of the harm to the separation of powers.
Breaking that.
Yes.
When the court does this peak, it looks at what is sought to be reviewed in Part B. And is there a prospect of success?
Yes.
It's an extremely delicate and almost difficult exercise because on the one hand, you don't want to prejudge or enter into the merits of any of the issues raised in Part A.
Yes.
Or of Part B.
Part B, yeah.
Yeah. But at the same time, you need to express a view on it.
Yes.
And that's the delicate judgment the court has to exercise.
Yes.
Without preempting, expressing a view which might be right or might be wrong, but it's important for the purposes of whether one grants the interim interdict.
Yes. And my Lord, may I make a submission about that?
It's how much of that peak one does, and it's really putting judges at the lower end of the totem pole, having to really take a peek and then almost put their thumbs in the air after sucking it a bit.
Lord, I'm glad I'm not in your position, but I have to say that it's not as bad as that. Firstly, as regards the totem pole, of course, tomorrow you could be sitting in the hot seat in a Part B application. So your position on the pole moves up and down. The one advantage you have is, of course, that whatever you decide is not binding on the court dealing with Part B.
Yes.
But the power that you wield is enormous, because you can, as I shall show in a moment, stop dead in its tracks something which would otherwise continue. In Outer, that was financially ruinous. That resulted in Judge Prinsloo's interdict resulted in the immediate downgrade of the credit rating of the South African National Roads Agency Limited. In the Pretoria street naming case, a delicate process, reconciliation process, part of transforming our new society, was stopped dead in its tracks. money had been spent, but quite apart from that, there was this other harm, which is hard to describe. I don't have proper words to describe it, but the Constitutional Court judgment eloquently in the first 30 or so paragraphs does. This particular case, similar considerations apply. So what the Constitutional Court is really saying to the judges is, in your position, is the thing that you really have to look hard at, you have to consider extremely carefully, is the harm, the separation of powers harm, as part of the balance of convenience equation which has to be drawn. That's the crucial job. Because even if one has a strong case, you still have to take that into account. But what they do say as a threshold level is you have to look at the merits of what it is intended to say. Let's take this no retrospectivity point. And you have to be satisfied, using the wording of the court here, that it is likely to succeed. Because it's only if you are convinced that it is likely to succeed that you may grant an interdict. And the way in which it was dealt with in the Qibani case by His Lordship Mr. Justice Binns Ward is instructive. And I'm just going to jump ahead in my note to take you to how he actually applied it. And it's at page 27 in paragraph 38.2. And I'll just read to you what I've said there. And this is after, first in 38.1, he states how he understands the outer principle, and with respect, this judgment is extremely helpful in a case like this one. But at 38.2, he then turned to an assessment of the applicant's prospects of success in the main proceedings. In other words, he undertook the peek into the applicant's intended grounds of challenge in the main proceedings mentioned in EFF interim interdict paragraph 42 at page 266 of the bundle. The principal relief sought by the applicants raises novel and complex constitutional issues. The outcome of the application for the principal relief is by the nature of the matter therefore essentially unpredictable. Some of the relief sought might reasonably be described as ambitious. Certainly this court isn't in a position without the benefit of detailed and considered argument from all sides and the opportunity for mature reflection to essay an opinion on the probable outcome of the application for principal relief. This must, in my view, bear on the issue of the strength of the prima facie case on which the applicants rely for interim relief. We submit, my Lord, that these 10 grounds that have been raised in this matter, none of them is clear-cut. None of them is one on which this court be convinced that the review is likely to succeed, or Part B is likely to succeed. Many of them are speculative, to put it at its lowest. And that with respect is the appropriate approach. Otherwise, there's another issue as well here, and it's this. One can get bogged down, as perhaps we have done, because of the way in which the applicant has presented this case, in detailed debate about the merits of these grounds of review. Whereas what's clear, what is required is not nothing more than an understanding of what it is that is intended to be argued at the end of the day, and an assessment of, based on this peak, as to whether or not the applicant is likely to succeed. And we'll see in some of the other cases how that is dealt with in relation to particular types of complaints. So in outer case, as regards the B requirement, if I can go back to page 23 of the note for the moment, para 32. In other words, the requirement carefully to consider the harm to the separation of powers that will ensue. In paragraph 26, the court said, the court must also be alive to and carefully consider whether the temporary restraining order would unduly trespass on the sole terrain of other branches of government, even before the final determination of review grounds. The court must be astute not to stop dead the exercise of an executive or legislative power before the exercise has been successfully and finally impugned on review. This approach accords well with the comity of the courts owed to other branches of government, provided they act lawfully. And then the two start melding together in a series of interesting passages. First in outer, paragraph 65 and 66 and 71, where the court said, when it evaluates where the balance of convenience rests, the court must recognize that it's invited to restrain the exercise of statutory power within the exclusive terrain of the executive or legislative branches of government. It must assess carefully how and to what extent its interdict will disrupt executive or legislative functions conferred by the law, and thus whether its restraining order will implicate the tenor of the division of powers. While a court has the power to grant a restraining order of that kind, it does not readily do so, except when a proper and strong case is made out for the relief, and even so only in the clearest of cases. You'll recall my submission earlier that this requirement, that it be the clearest of cases, that relates to the interim interdict case as a whole, not just to the prima facie right requirement. A court must carefully consider whether the grant of the temporary restraining order pending a review will cut across or prevent the proper exercise of power or duty that the law is vested in the authority to be interdicted. What this means is that a court is obliged to ask itself not whether an interim interdict against an authorized state functionary is competent, but rather whether it is constitutionally appropriate to grant the interdict. And in paragraph 71, before granting interdictory relief pending a review, a court must, in the absence of mala fides fraud or corruption, and as I shall show you in a later case, that means proved mala fides fraud or corruption, examine carefully whether its order will trespass upon the terrain of another arm of government in a manner inconsistent with the doctrine of the separation of powers. That would ordinarily be so if, as in the present case, a state functionary is restrained from exercising statutory or constitutionally authorized power. In that event, a court should caution itself not to stall the exercise unless a compelling case has been made out for a temporary interdict. Even so, it should be done only in the clearest of cases. This is so because in the ordinary course, valid law must be given effect to or implemented, except when the resultant harm and balance of convenience warrants otherwise. Then in AFRI forum, at paragraph 43, the majority of the Concord added the following. Operating with the ever-abiding consciousness of the crucial role of separation of powers plays in our constitutional democracy, courts should thus be very slow to interfere with the legitimate exercise of governmental powers, save in the clearest of cases or where bad faith or corruption or fraud was proved. Even the common law recognizes that courts should exercise the power to grant an interdict restraining the exercise of statutory powers only in exceptional circumstances and when a strong case is made out. And in the EFF case, just the other day in May, the court summed up the approach as follows. We were cautioned by this court in outer that where legislative or executive power will be transgressed and thwarted by an interim interdict should only be granted in the clearest of cases after careful consideration of the possible harm to the separation of powers. Essentially, a court must carefully scrutinize whether granting an interdict will disrupt executive or legislative functions, thus implicating the separation and distribution of powers as envisaged by law. In that instance, an interim interdict will only be granted in exceptional cases in which a strong case for the relief has been made out. Now, one of the crucial things in a case of this kind is the prejudice which is sought to be averted by the applicant. And in AFRI forum, at paragraphs 55 to 61, the majority dealt at some length with the requirement that an applicant for interim interdict pendente lite must have a reasonable apprehension of irreparable harm, which must be irreparable and imminent, and that should the interim order not be granted. And in this regard, we refer to paragraph 59, in which the majority emphasized the following. Irreparable implies that the effects or consequences cannot be reversed or undone. Irreparable therefore highlights the irreversibility or permanency of the injury or harm. That would mean a favorable outcome by the court reviewing allegedly objectionable conduct cannot make an order that would effectively undo the harm that would ensue should the interim order not be granted. So the focus is on the alternative remedy which would be available at the end of the process, and whether what has happened in the meantime cannot be effectively undone. Now, these principles were applied in 3 earlier cases by judges in which this court has been asked and has refused to interdict proceedings in Parliament aimed at exercising its oversight power over organs of state. So the court has the benefit, These general principles formulated in other contexts have been applied in this court on 3 occasions in cases very similar to the present. The first case is Qibani, and the court knows that is in our bundle at page 1083. That was a case where the applicant sought an interim interdict restraining the Speaker from scheduling a vote on a motion of no confidence in the then President, pending the final determination of an application to have the Speaker declared unfit to hold office. That was one of the elements of the relief sought in the big case, to which we have quoted in 26.3 on page 20 of our note. It's discussed in our heads at para 231, and in the course of his judgment, Justice Binsward quoted the following passage from his earlier judgment in the City of Cape Town versus Sunral matter, 2013 ZAWCHC, page number 74 of 21 May 2013, paragraph 75, in which he described the judgment of the court in Outer. And this is, with respect, a useful early summary of the development of the law in this matter. It was decided between Outer and AfriForum. I've concluded that the intention in the reasoning of the majority judgment in Outer was to reiterate as a matter of established constitutional principle that courts seized of applications for interim interdictory relief pendente lite in matters where the functions and powers of the executive or the legislature are susceptible to being restrained must be consciously sensitive to the impact on the constitutionally ordained separation of powers of any order they might be inclined to consider making restraining the use of executive or legislative power. Then we emphasize, where on such assessment the impact of the restraining order, what the Constitutional Court labelled for convenience as balance of power harm, looks to be significant, a court will incline against making the order unless a strong case for the relief has been made out, and only in the clearest of cases. A strong case would be one in which the right at issue, although established only prima facie and open to a measure of doubt, nevertheless appears to enjoy good prospects of being established in the main proceedings, and also one, so it's the right element, and also one in which the need for intervention of an interim interdict is clearly shown if irreparable harm to the applicant is to be averted. In other words, a case in which the balance of convenience clearly militates in favour of the granting of the remedy. So there are 2 elements here, my Lord. The first is that there has to be a strong case on the merits. Good prospects of being established. So the prima facie right requirement is bumped up in a case of this kind. And the second is that the balance of convenience, including this careful assessment of the separation of or balance of power harm, clearly militates in favour of the granting of the remedy, and there crucially is whether there is irreparable harm. I'm sorry. Now, such a construction would give effect, in my view, to the evident intention of the Constitutional Court judgment, firstly, to confirm the application of a well-established requirements of the interim interdict remedy in such cases, and secondly, to explain how they should be applied in a manner consistent with respect by the courts for the constitutional scheme of a separation of powers, where the remedy would restrain the exercise of executive or legislative power. And then we emphasize, the greater the impact of the impinging effect of the postulated restraining order on the domain of the executive or the legislative branches, the more circumspect and demanding of the applicant's case the court will be before deciding that it's appropriate to grant it. The principle that a court doesn't lightly grant an interim interdict pending the review of executive action, even if all the requirements for an interdict have been established, is nothing new. The Constitutional Court in Outer has fleshed out the articulation of the principle. Then follows the paragraph which I read earlier about this case raising novel and complex issues. And then, crucially, His Lordship applied the Ericsson Motors discretion as a, in his conclusion, paragraph 38.3 at page 1092 of the bundle. In the circumstances, I am not persuaded the applicants have established all the requirements for interim relief. So that's on the application of Outer. But even if I were wrong in this regard, I would not be inclined, in view of the separation of powers issues involved, to exercise my discretion in their favour. Now, the second case in which a judge in this court has been asked and refused to, and has refused to interdict proceedings in Parliament aimed at exercising its oversight power and duty over organs of state, is Mahla Loga's case, which is another judgment of Binns Ward J. It's discussed in our heads at paragraph 632, and it deals with the application of the provisions of Section 6 and 8 of the Independent Communications Authority of South Africa Act 13 of 2000, regulating the removal of ICASA councillors from office, which are quoted in paragraphs 4 and 5 of the judgment. And the court will see they are provisions which are similar to Section 194 of the Constitution in certain key respects. The interesting thing about ICASA, my lord, although it's referred to in Section 192 of the Constitution, conceptually, the details are left to national legislation, in contrast with all of the other Chapter 9 institutions where there's a bit more flesh on the bones in the Constitution itself. But what's happened in this case is that the details in the statute closely resemble what one finds in 194. And we refer to the following paragraphs of Judge Binns Ward's judgment in particular, 16, 19, 20 and 21. It appears plainly from the provisions of Section 6 and 8 of the ICASA Act quoted above that it's within the exclusive functional domain of the National Assembly to make a finding whether the applicant is disqualified from office in terms of 6.1J, and whether it should on that account adopt a resolution to remove him. Necessarily inherent in that acknowledgement must be an acceptance that making a primary finding on those questions is not a judicial function. And my lord, I cannot emphasize that enough. It goes to a fairly lengthy discussion that we had earlier on about the nature of the job which is performed by the National Assembly under 1941B and 1C. The applicant contended that he could not be afforded substantive relief once the parliamentary process had been completed, because his appointment would be forfeit by then and someone else would have been appointed in his place. The rest of the paragraph goes on to deal with financial harm, etc., that he will suffer. The applicant had no right to preemptive protection against the operation of the Act according to its tenor. And I just wish to pause there. Lord, this goes to the discretionary nature. This kind of relief is not claimed as of right, and rightly so. It is in the discretion of the court, and it involves the delicate balancing act to which your lordship referred earlier. So he was not entitled to ask the court to make the finding provided for in 8.2a of the Act when the legislature has allocated that responsibility to the National Assembly. The only right that the law gives him is to ask the court to strike down any decision the National Assembly might take if he were able to show that it had acted unlawfully. So it focuses on the Part B. He has a right to bring that. It would be in the context of an application for that form of substantive relief that he might be advised, if he were to make out a proper case for it, to seek interim relief pending the effect of the impugned parliamentary resolution, pending the determination of his complaint about its legality. And we're in that scenario at the moment in this matter. The substantive effect of the purportedly interim relief actually sought by the applicant would be to prevent Parliament from exercising its responsibility. Same applies here. That would be plainly inimical to the proper administration of the ICASA Act, which is an important instrument. It's the legislation enacted to give effect to Section 192 of the Constitution, and also intimately bound up with the discharge by the state of its duty in terms of Section 7 of the Constitution to promote and protect the fundamental rights to freedom of expression and political choices. Parliament would fall short in fulfilling its responsibility if the organ of state it created for these purposes were not structured and maintained in a way that inspired public confidence in its integrity. The third case in which a judge in this court has been asked and refused to interdict proceedings in Parliament aimed at exercising its oversight power and duty over organs of state is Qibani. It's a judgment of Henny J, and it's discussed in our heads, para 233, pages 116 to 117, and it's in the bundle at page 573. It concerned proceedings in Parliament in terms of Section 12(6)(c) of the National Prosecuting Authority Act 32 of 1998, aimed at a decision by Parliament whether or not the applicant, a Deputy National Director of Public Prosecutions, who'd been removed from office by the President in terms of 12.6a, should be restored to office. So that was the NA's power. It could direct that the person be restored. The applicant, and to that end, there was an inquiry was envisaged into the facts and circumstances that had led to her being removed by the President. The applicant contended that properly construed Section 12.6 did not permit her removal from office prior to the conclusion of the process in Parliament. Henny J rejected that contention, and then against that background, and as appears from paragraph 66 of His Lordship's judgment at page 583 of the bundle, in the alternative, the applicant sought interim relief pendente lite, namely an order that the President and the NPA be ordered to reinstate her to her position pending the outcome of a review of the President's decision to dismiss her. As Henny J pointed out in paragraph 68, what the applicant was thereby seeking to do was to forestall the operation and proper function of the NPA Act, which permits her removal. And so after quoting passages from Mahla Loga's case, Henny J concluded as follows, and we referred page 586 of the bundle, paragraphs 71 and 72. In my view, the applicant has failed to make out a compelling case for this court, exceptionally to preempt decisions falling within the competence of Parliament. The court would intrude upon the oversight function of Parliament, which it generally has in terms of Section 55 of the Constitution and has expressly been given in terms of Sections 12.6 C and D of the NPA Act, to give effect to protecting the independence of the NPA. This oversight function requires Parliament to deal with an inquiry for restoration of the applicant in an expeditious manner. This process clearly seeks to protect the applicant and further seeks to protect the independence of the NPA, contrary to what the applicant alleges. And it is based on the doctrine of separation of powers. It further requires that the inquiry into a restoration is not unduly delayed. The Act requires Parliament to act expeditiously, and it seems at the time when these proceedings were instituted, Parliament had already started with the process set out in Section 12.6c by having invited the applicant to make representations. It would therefore be an unwarranted and unjustifiable invasion of the separation of powers in circumstances where the applicant has not made out a compelling case. This court cannot usurp the functions and duties of Parliament. In respect of Prayer 5, the applicant, in my view, has failed to make out a case for the relief it should be she is seeking. Now, my Lord, in this present case, Parliament had already started with the process. It's common cause that the Speaker has accepted the motion and has called on political parties to nominate members for the independent panel. Once that panel is appointed, she will be invited to make representations. That's the duty of the panel. It has to do so. So the case is in a very close correspondence in terms of where in the procedure one finds oneself with the present matter. So we say, applying these principles to the present case, that nothing short of a very compelling case on the merits will justify the exceptional remedy of staying a 194 process before it started in earnest. This is because the incumbent of a Chapter 9 office does not have a general right to preemptive protection against the operation of Section 194 of the Constitution and the new rules according to their tenor. More specifically in this case, Advocate Qibani does not have a general right to prevent the National Assembly from exercising its responsibility to undertake a Section 194 process in accordance with the new rules when, as has now happened, a member of the National Assembly has lodged a substantive motion calling upon it to do so. We further submit that in addition to a very compelling case on the merits, Advocate Qibani has to show that she reasonably apprehends that she will suffer irreparable and imminent harm if an interim interdict is not granted and she's ultimately successful with her Part B challenge to the new rules, and linked to that, the absence of a suitable alternative remedy. And further, she has to show, and if she overcomes those hurdles, that the imminent and irreparable harm she will suffer outweighs the serious prejudice to the separation of powers and the public interest in the timeless conclusion of the Section 194 process that will ensue if the interim interdict she seeks is granted. In what follows, we shall deal as briefly as possible with those of the 10 grounds on which she seeks the relief in Part B of her notice of motion, which were dealt with in oral argument yesterday, and on which the right she is seeking to protect in the interim by means of the interim interdict is based, none of which we submit is compelling. Before doing so, however, we'll address two issues. The first is the irreparable harm on which she relies, the alternative remedies at her disposal, and the balance of convenience, especially the harm to the separation of powers. and to the public interest in the time is conclusion of this process if the interdict is granted. And second, we'll deal briefly with an issue which underlies and we submit undermines her procedural unfairness attacks, namely that neither the making of the new rules by the NA nor the implementation of the new rules in an impeachment process initiated in terms of those rules is administrative action under PAJA. My Lord, I'm conscious of the fact that it's 1:10, but I'm very happy to continue because I realize we are under a tight time frame.
We thought perhaps we should continue until 1:30 and then break until 2:15.
Thank you, my Lord. So my submissions on the irreparable harm alternative remedies and the balance of convenience are relatively brief. We deal with, firstly, the reasonable apprehension of irreparable harm. It's dealt with in our heads at paragraphs 219 to 226. And we start by pointing out that in Advocate Qibani's founding affidavit, it's at page 76, para 175. Unfortunately, at that juncture, there's a confusion with the paragraph numbers, as the court knows, and one drops back into the 130s. But it's quoted in our heads at paragraph 219. She's adamant that her removal from office pursuant to the section 194 process put in train by Ms. Mazzoni's motion cannot reasonably be apprehended. May I ask you just to turn to our heads, my Lord, pages 109 to 110. One sees in footnote 258 at the bottom of page 109 the reference to the relevant paragraph, and there's the statement. I'm just going to read it, my Lord, because it's foundational to our submissions on this issue. She says, and I quote, "On the topic of destabilization and the nuisance value of the alleged motion, I need to make it clear that the harm which I, members of my staff, and the public is likely to suffer is not really so much my intended removal. That is very unlikely to happen, given the fact that the DA which is championing this politically lacks both the numerical strength and credibility to obtain the requisite 2/3 majority for my removal. It might have attracted a few opportunistic political fellow travellers since then, but not to the extent of conceivably achieving the requisite magic number of 267 votes. That's the 2/3 majority absolute of the 400 members. Such an outcome cannot reasonably be apprehended. Even in the unlikely event of the DA somehow spreading its influence by threefold its numerical strength, it will still fall short of the target by 15 votes. So she says in terms, I do not reasonably apprehend being removed. She has all sorts of reasons for that, but that's her case. And so one's not dealing with a situation, as in Mahla Loga's case, where the person was saying, I'm worried I'm going to be removed in the interim and I'll suffer irreparable harm. She's not worried about that. She herself says she doesn't reasonably apprehend that.
And for the
second issue,
purposes of interim relief, that must be positive.
Yeah. What about her suspension?
There's no risk of her suffering irreparable harm.
Yeah.
Then why is an interdict being sought? Other than on what has been described at length is the sanctity of the constitutional provisions and the fact that the rules breach various tenets of the Constitution and of the common law. But the application is brought by her to prevent a process in respect of her.
Yeah. It's really the end of the...
is to deal with it in interim basis.
It's the end of the application.
With the more broader issues.
Yeah. It's the end of the application with respect. Because these points, these merits points, they go to the prima facie right requirement. But there are 4 requirements for this relief. And this particular one, irreparable harm, it has to, firstly, it has to be there. And we'll see that she does claim some harm, not this harm of removal, but other harm. And secondly, it then gets put in the scales, together with the separation of powers harm, which I've just addressed at some considerable length. Now, I just need to be fair to her, and let's look at what she says. The second possibility is her suspension in terms of 194.3a by a person with a conflict of interest. Now, let me say immediately, my lord, she could never complain about her being suspended through the taking of a proper suspension decision by someone who doesn't have a conflict of interest, because that's what the Constitution provides in section 194.3a. So one could never complain about, I will be suspended if the National Assembly decides to initiate the committee process. Her case, what she was concerned about was that someone with a conflict of interest would suspend her, and one sees that in the founding affidavit. The person in question is the President. Why? Because the President is engaged, at that stage was engaged in litigation with her concerning the Bosasa report, or the CR17, a matter which leave to appeal was refused in the High Court, but the Constitutional Court has accepted the case for argument on the question whether leave to appeal to it should be granted, and if so, whether the appeal should be upheld. That is the matter where we gave the wrong date. The hearing for that date is 29 September. So there is live litigation between her and the President. But we know that the President has catered for that contingency by filing an affidavit. He did so on the 17th of February already, saying that he has, I put it too strongly in paragraph 48, with apologies, my learned friend Ms. Bauer will correctly, he says he has a potential conflict of interest. He doesn't concede an actual conflict, but he says, because of that, I will delegate my powers under section 1943A of the Constitution to another member of the National Cabinet. There is provision made for that in the Constitution, who doesn't have a conflict, should the need arise for that person to consider Advocate Qibani's suspension during the section 194 process. In other words, if there is a resolution to refer the matter to a 1941B committee. So we submit that the possibility of an unlawful suspension can be discounted. So this passage I've read to you starts with the topic of destabilization and nuisance value of the alleged motion. And that takes us to a true case on this aspect of the matter. She confines her case, it seems to us, on this issue to the destabilization of the Office of the Public Protector that the section 994 process will cause. And that's over the page in her founding affidavit on page 77. It's in the second of paragraphs 138 and 139. And to what she calls the nuisance value of the alleged motion. That's the first paragraph 175 of the founding affidavit, the passage that I've just quoted. Now, she does not explain in what way the continuation of the section 194 process will cause irreparable harm to the Office of the Public Protector or to the public which it serves. And those we submit are the relevant interests. It's not her personal interests. It's a part of Mohlaloga's case, paragraph 19, which I didn't quote to your lordship. We submit that being held accountable by the NA in terms of a provision in the Constitution designed for that ultimate purpose, section 194, on the basis of the motion brought by Ms. Mazone, is not legally cognizable harm to Advocate Qibani or her office. In other words, I'll just make that submission clear. What comes with the territory, my lord, is that if you get appointed to this office under section 193 of the Constitution, that the possibility exists of someone in the National Assembly bringing a motion under section 194 for your removal. It comes with the territory. So the fact that such a motion is brought is not legally cognizable harm. It's something which you are exposed to or liable to have to endure because you are the incumbent of a Chapter 9 office. And we accept that, of course, there may be frivolous motions, vexatious ones which are a waste of time and which are indeed a nuisance. But the rules following the decision in EFF impeachment contain screening mechanisms. Speaker screening mechanism, where she checks that the allegations which are made are ones which, if proved, fit the bill. and that the motion is supported by the evidence and otherwise compliant with the constitution, rules, and the law. And second, the second screening mechanism, where the incumbent has the opportunity to tackle the motion, as it were, and the evidence on which it's based. So it's not as though there is no protection against so-called nuisances. And one must also bear in mind, my lord, that the busybodies, or the people causing the alleged nuisance, are none other than members of the National Assembly. We're a population of well over 50 million people in this country. Only 400 of them are representatives in the National Parliament. And it does concern me and my client, through me, that in the passage that I've read to you about the bringing of this motion, and generally in the submissions which you have heard, is an undertone of contempt, thinly disguised, towards the members of Parliament, who are our representatives and who have this important function. So I would submit that, as in the case of a recusal application brought against a judge, one should approach a claim such as the present, that one is dealing with a nuisance, with a healthy dose of skepticism. Every member of Parliament has taken the oath of office required by the Constitution, and I can say without fear of contradiction that on these papers there is no evidence whatsoever that the motions that have been brought, and particularly the final motion, the one which is operative at the moment, is a frivolous or vexatious motion. Yet we find that Advocate Qibani describes this as a nuisance. This motion has nuisance value to her, her words. We submit it is not proper for her to describe it as a nuisance. And in this regard, we emphasize that her motion is based largely on trenchant criticisms by judges of the High Court and justices of the Constitutional in the Court in the cases to which I've referred, of her performance of important investigations and her conduct in litigation about her ensuing reports. And I mentioned to your Lordship that we would be taking you to the Institute of Accountability case on this aspect. And it's in the bundle at 556, but it's quoted at page 34 of the note. The first paragraph is paragraph 31. And I strongly suspect your Lordship presiding is aware of this because of a remark which he made to my learned friend yesterday, aware of this passage, when discussing the status of those criticisms. What his Lordship, Mr. Justice Coppin, said at paragraph 31, following the relevant findings in these cases, relevant because they underlie the charges, as the following. Even though such findings constitute expressions of opinion, they cannot be equated with the opinions of ordinary individuals and cannot be treated as such. Those findings were made by judges and confirmed in certain instances by the justices of the highest court in the land. Judges have a duty to form and express opinions concerning issues raised before them, including those that are relevant in the context of this matter. And they arrived at those opinions aided by procedures including the law of evidence, which was designed to ensure that they base those opinions on the correct information. Those opinions are also binding on all persons and those organs of state to which they apply. And in paragraph 34, his Lordship added, it cannot convincingly be gainsaid that the adverse findings of the kind referred to earlier and relied upon by the Institute concerning Ms. Qibani and her capacity as public protector are, and we emphasize, of grave concern, and that the public interest requires these issues raised by those findings be addressed expeditiously and without delay. And it's also not without significance that it appears from the Institute of Accountability case at paragraph 35, and I alluded to this earlier. It was submitted on behalf of Ms. Qibani that her fitness to hold office as the public protector is governed by section 194 of the Constitution and is reserved for decision by the National Assembly. Accordingly, so it was argued, the application, and this was for the court to find that she was not fit and proper, is an attempt to usurp the power of the National Assembly, constitutes the clearest form of abuse of the court process for political reasons, and is the clearest illustration of the breach of the separation of powers principle. What we submit is that her contention in the present case to your lordships and ladyship that Ms. Mazzoni's motion is merely a nuisance is, to put it at its lowest, hard to reconcile with the stance she adopted in the proceedings before Cop and J. We must not be misunderstood as saying that Advocate Qibani is bound to be removed from office pursuant to Ms. Mazzoni's motion. On the contrary, as pointed out in our heads paragraph 224, pages 111 to 112, the section 194 process is in its early stages. The Speaker has taken the third of the 17 steps in the process described in paragraph 71 to 96 of our heads. Consequently, if and when the section 194 process continues, there's the possibility of the NA, after considering the report and recommendations of the panel, resolving that a section 194 inquiry not be proceeded with. If such an inquiry does ensue, there's also the possibility of the section 194 committee deciding at the end of the inquiry that none of the charges levelled against Advocate Qibani by Ms. Mazzoni has been established, i.e. that Advocate Qibani has not misconducted herself and is not incompetent for the reasons given by Ms. Mazzoni. And thirdly, if the section 194 committee does decide that she's misconducted herself and or is incompetent for the reasons so given, there's the possibility of less than 2/3 of the members of the NA supporting the resolution for Advocate Qibani's removal from office. In this regard, we reiterate that her case is that it's very unlikely that she will be removed. So, in conclusion, we submit on this aspect that she does not reasonably apprehend any irreparable harm. My Lord, is this a convenient time to take the adjournment?
So we'll adjourn until 2:15. Thank you.
Thank you, my Lord.